for coming earlier than we normally convene. That being said, I've been asked if we could maybe adjourn today at 4:30 for certain good reasons, and I've agreed to that. So we'll rise at 4:30 today. We adjourned last night while Mr Ferguson was cross-examining Mr Early, and that gave rise to an issue about one of the Council's documents. And I'd like to start today by getting to the bottom of that a little, because as I looked into it further, I realised there seems to be a problem about EDC 131. And I should start with an apology to Mr Ferguson, because, as he said, it's not available on the public website, which I wasn't aware of. Our use tends to be of the DPA version of the document, so of course contains documents that are not in the public domain. So I had what turns out to be part of document 131. Can I just ask, first of all, Mr Ferguson, the document you were starting to use yesterday, the one that was called EDC 131, the version you were about to use, did that come out of the box of documents that the Council had left you?
No, it was the original document as it was submitted, ma'am.
The original document, in what sense the original document has submitted?
In when the Council's representation submitted it to the DPA, it was archived.
EDC 131 was? You see,
yes.
What I'm advised is that EDC 131, which does appear partially on our record, was an Excel document. And for reasons I don't understand, it would appear that that's not a document that we can publish it because of formatting reasons. Now, what should have happened, I think I'm right in saying, Ms Hamilton, this was a December batch of documents. This documents lodged by the Council in early December.
I would need to check, ma'am. It certainly could have been.
Yeah.
There were documents lodged around the time, certainly around that time.
Yeah, I think my recollection of it is that it would be in and around the time when Mr Ferguson had raised a request for me to make an order for the production of documents. And I think a batch of documents was prepared and lodged around that time that responded to Mr Ferguson's request. These are the ones that Council agreed to provide him with. Now, what my office is at that point, unfortunately, the former case officer was unwell, and as you can imagine, it was a time when my office was under pressure, just as everybody was, in December of 2020. So what should have happened, from our point of view, was that the document should have been requested from the Council in a form that we could publish. That's what should have happened. The version that I have access to is just is 2 pages. It's one Excel page, and I don't have subsequent pages. And I asked for you to give me a copy today, Ms Hamilton, and I see that in fact it's got several pages. So that's correct. Can I just confirm, Mr Ferguson, have you got all of these pages?
In the format that I have the document, ma'am, it's 4 pages. 4
pages. Well, I think we're working for but this is a document that I haven't previously seen. I thought I'd got it, but in fact I only had the first page. Can I just clarify, before we proceed, exactly what this document is, Ms Hamilton? What is it?
It is, as I understand it, it is a breakdown of figures relating to, I suppose, what we are calling a minimum refurbishment option, in that the owners were given a range of cost estimates relating to a refurbishment option, from doing a kind of bare minimum approach in relation to the block, to at the other end of the scale, and this being the option that was included within the feasibility study, a sort of full refurbishment, full internal and external, as is described in the feasibility study.
So I see that this has the logo of Langmuir and Hay, and at least I think both my version and this version does. So this was produced by the QS firm instructed by Coulthard Early, is that correct?
I'm not I can only
Your guess
say
is
what
divine
I...
on this occasion, is it
yes.
now? Okay, which would suggest that Mr Earley may or may not be in a position to answer questions about it. Is that, are you familiar with document 131? Have you got all of it?
I hadn't seen it until the documents for this hearing were issued.
All right.
So I wasn't party to checking it or anything, but I'm happy to talk about the numbers on it, I think.
Are you? Right. For whatever reasons, your firm wasn't involved in the instruction of these updates or whatever, or the postings, is that correct?
Correct.
Right. Ms Hamilton, was this generated for the purposes of discussion with the... Well, when was it generated? If I can ask you that. When was it generated? That's something I would need to need to check. Could you establish that for me, please? Could you establish when this was, what the date of this document is?
Yes.
Now, there is another document. I just wondered, sort of correct my own assumptions. It's always dangerous for the reporter to develop assumptions. There's a document, EDC 101, which is called Elemental Cost Plan. Can you tell me what that is?
Yes, that is a further breakdown of costings relating to the redevelopment option. And as I understand it...
Option 4.
Yes, option 4. And those figures were instructed as an update to the original figures which were contained within the feasibility study.
Right, so...
And I believe that I can give you a date for those.
Just now you can?
Yes.
Can you tell me what that was?
Yes, those were produced in March 2020.
March 2020. So that's basically, that's part of the, if you like, the Council's original case building process, is that right? March 2020, that would be the first tranche of documents from the Council around that time?
Yes.
Right, well, that diminishes my confusion if it doesn't eradicate it. Right, can I just double check, Mr Ferguson, you've had this document since December, is that right?
That's correct, ma'am.
All of it?
As early as it was submitted, yeah.
Well, that was my main concern.
Yep.
I wondered if perhaps you'd only seen it, this morning. But if you've had some time with it, that's fine.
I should say, ma'am, that in preparation for the original inquiry date, Brodie's issued the objectors with a zip file containing all of the documents at that point. So I'm assuming that the objectors had the full version direct from Brodie's at that time.
And it looks like that was correct. Could you make sure that your clients liaise with my office to make sure that a legible version of 131 is now presented,
available, yes,
so that we can publish it? Now, what was it? What else did I want to pick up? It's gone. It's gone. Right. Okay. So, I find, as often happens, I was the most confused person in the room rather than least confused. So, if you would bear in mind, Mr Ferguson, as you begin to question Mr Earley, I assume you do want to question Mr Earley about this document?
Yes, ma'am.
Yeah. If you would bear in mind as you proceed that it's new to me just now, and I may have to interrupt just to be absolutely clear that I'm following it. Okay, now that tidied up to my satisfaction. Does anybody else have any other preliminary matters that we should sort out before we resume questioning? Ms Hamilton.
Yes, ma'am, I had one preliminary matter which I was wishing to raise just at this point, and it relates to some questions which you had for Mr Brodie at the end of his session yesterday, and you asked him a passage of questions relating to the various options which may or may not have been available to the Council under the housing legislation or other legislation.
Yes, I asked him about repair notices and other things.
That's right. I would like to lodge a copy of an extract from the Housing Scotland Act 2006, which was mentioned yesterday, because it came up directly in questioning. Now, I'm aware that you had mentioned that this might be something that we would pick up in closing submissions, and that is something I would intend to do, but I'm conscious that if we just come to it at that point, it may actually place the objectors at a disadvantage, and what I would like to do is really one section from the 2006 Act, which I can circulate, or I've got copies that I can give out to everyone now.
Could you please do that? Could you please give copies? Objectors, Ms Hamilton's asking to lodge an extract of some legislation which has not previously been lodged as a production. In fact, the Council needn't have lodged legislation as a production at all, because the law just sits there in the background, but they have lodged it, I assume, for ease of reference, and that's quite helpful. Yesterday, I asked Mr Brodie about the options that were available to the Council to compel repairs on the block and then to recover costs. And Ms Hamilton has, I think, rather helpfully asked to lodge that material. Without prejudging how that would play, in my preliminary view, the lodging of this document may be helpful to you, because it entails the options that the Council could pursue of rehabilitating the existing block and then being in a position to recover costs from you on a compulsory basis. Understand about that? So the first thing I want to know is, do any of you object to the Council lodging this extract from the Housing Act 2006?
No, ma'am.
No, and Mr Farrell, you quite happy? Ms Macmillan? Yeah. Mrs Ferguson, you happy too? Right, Ms Hamilton, there's no objections to that, so that's a good idea if you would lodge that. Do we need it today? Probably not. I mean, just for adding it to your inventory.
And I think it would become EDC 139.
Right.
Ma'am, I just realised, in looking again at my version of EDC 131, sorry, going back to our earlier discussion.
There's always one. There's always a production that causes disproportionate numbers of copies of problems.
I actually have a note on it of February 2018.
Oh, right. February 2018.
If I'm able to help with that, ma'am, that's when the document was originally produced and commissioned by whomever produced it.
I was just asking Ms Hamilton what date it was, because the document on its face is undated.
I recall actually that it's discussed in the response to the EIR request from Mr Ferguson, which you referred to, and that is where that date comes from, which can be cross-checked if anyone. Yeah. Yep. So I think Mr Ferguson's obviously agreeing with that.
Yeah. Right. Okay. So good. If you object to the copy of the document that you've just been handed, the new document, if you could perhaps mark that up with its reference number, EDC 139, just so your papers are all tidy. As I say, I don't envisage we would be referring to it today, but maybe we are. Maybe we might. And reflection of the witnesses
Possible.
Today. Yeah. Okay. Do you have any other preliminary matters, Ms Hamilton?
No, ma'am.
Right. I think we can get started then. Okay. Right, Mr Ferguson, would you like to resume your questioning of Mr Early?
Yeah, thank you, ma'am. Good morning again, Mr Early. So if we could just go back to document EDC 131, which we were discussing yesterday. I'd just like to go through some of these costings with you now, to the best of your ability as they're in your report, to better understand how those figures were arrived at. Is that something that you'd be able to do for us today?
I can try my best with this. As I said, I hadn't seen the document until recently.
Thank you. So yeah, page 4 of document EDC 151, which speaks about the common stairwell in the building. Do you have that available?
I will have it. I'm not sure about the numbering of the pages. If you can tell me, is there a heading?
I think it's the final page, really, isn't it?
Yeah, that's right, ma'am. It's common stairwell is the title, and it's allow £50,000 is written at the bottom of it.
I've got that.
Helps. Got it. Okay. So for the common stairwell, which to the best of your understanding, would that be the common stairwell in Block 1 or Block 2 or both?
Mr. Ferguson, terribly sorry. I'm struggling. Common stairwell, which section will I find that?
So it's the page 4 of my document, ma'am.
Yeah.
It depends. If you printed it in a portrait format, it might be different.
Yeah, I've got. I have a copy provided to me by the council, and it's quite hard to see how this. What was landscape? What was the actual spreadsheet originally, and what wasn't?
Would it be helpful if I just shared?
Well, actually, it's not. I found the heading "Common Stairwell," and that's actually on the second page of the group that's been passed to me, and it's at the bottom of the page. Does that look like the right place?
Yeah. So just to confirm, ma'am, but the next thing below that is new front closed door. With a figure of 2,500 to the right of it, is that right?
No, I'm not seeing that at all. I am less and less convinced that I've got the same document as you have. Yeah. You're going to trust Miss Hamilton to believes that it doesn't have a box round it. Yeah.
And then the first small entry.
What did you say about another something below that, Mr. Ferguson? What did you say?
So they all have figures that say allow. So that's obviously the allowed expenses. So it says allow 50,000 below it and allow 150,000 above it.
Yeah.
Yeah. So it's just that section in between.
Okay. Thank you, Ms. Hamilton. Thank you, Mr. Ferguson. As I say, bear with me. That wasn't the fourth page. It was part of a spreadsheet. Right. Let's see how we get on.
Yeah. So yeah, just to reiterate, Mr. Riley, to the best of your understanding, common stairwell, does that refer to the main stairwell in Block 1, Block 2, or both blocks?
I would imagine it's referring to either block if they were being done up to the specification that the council would prefer to do.
Okay. And so the first costing that's given in here is a new front closed door if the block was being done up, which has a unit cost listed as approximately £2,500. The front closed door currently is functional and in very new and very good condition at 30 to 50 Nithsdale Crescent. Could I just ask why, in design terms, would it be necessary to cost for a new front door when one was just put on that's still in good condition?
If that was an element that was considered unnecessary by the joint owners, then that's something that could be considered repair instead of renewal.
Yeah. And I'm just aware that, as a kind of lay person when it comes to planning and whatnot, I might be missing something here. So is there anything in your experience that would necessitate a new door when there's a functioning door in good condition by a planner?
I don't have detailed information on the current condition of the door. It's been a while since I was out of the building.
Yeah. Or any doors. Has there ever been a situation like that in similar projects you've dealt with?
Pardon?
Has there ever been a situation in similar projects that you've dealt with where a functional door has had to be replaced?
Yes, there's been situations where functional doors have been replaced because of the requirement of new electronics going in. In this case, I couldn't state if that's the case or not.
Okay. Thank you. So yeah, just next kind of item in there, the external store door. So it's my assumption that refers to the outdoor bin storage, which we briefly touched on yesterday in reference to the refuse chute. Again, there's already two completely functional doors that are in good condition, is there any reason that you would be aware of that it would be necessary to spend £3,500 to replace those doors?
If they're in good functioning condition, it would be a decision of the owners to replace or not, in terms of how they would like to plan future maintenance of the building.
Okay, thank you. We went over the refuse chute yesterday, so I don't really think that's necessary, but again, would you say...
I don't think we finished the line, actually. I think that was the point at which I began to realise we weren't looking at the right document. So I would quite like to revisit that. I think what you're saying, Mr Ferguson, and correct me if I'm wrong, you're suggesting that's an excessive quote for the redesign of the, I assume it's refuse rather than refuge chute.
Yes, ma'am.
Is that really what you're saying? £15,000 is an excessive?
Yeah, as it appears, the main issue with it being that, again, the refuse chute is completely functional and is a structural part of the building as well. So
well, let's see if Mr Hurley has could you possibly even remind me of what you said about that? How does the suggested cost of £15,000 for the redesign of the refuse chute in Block 2, insofar as you know about that, how does that strike you? Is that an excessive amount? Or?
Well, the costs for under redesign of refuge chute include for the construction of a remote bin store. Right. And also to do away with the existing chute, which would be considered as a fire risk and health risk under current legislation. Blocking up at each floor, removing the hatches, bricking up, etc. So it's not actually redesign of refuge chute. Yeah. It's renewal of the refuse disposal system and structure to accommodate that.
So again, £15,000 doesn't strike you as an excessive amount, or
no?
It's a reasonable estimate?
In my opinion, yes.
Okay, so we've looked at the store door and the right. Mr Ferguson, carry on, please.
Just if I may ask, Mr Early, just on that, to clarify a bit further, the health risk and the fire risk posed by current legislation, would you be able to elaborate on what that legislation is and why that would necessitate the replacement of the chute as it stands? Because what that suggests to me is that the building that I am living in, which we've already touched on, we'll get to that in further questions, is unsafe, is what's been suggested by some of the documents submitted by the Council. Could you just clarify what legislation that is and what would necessitate that?
Mr Ferguson, that's just too big a question. It's just too open a question. Can I try recasting it? And if it's not satisfactory, Mr Earley, is there a specific piece of legislation that would render the current refuse arrangements unsatisfactory from a technical and architectural point of view?
Yeah, the access to a building for firefighting.
But so it's not so much legislation, or is that regulations?
Sorry, regulations, technical standards.
It's technical standards. So is it the building regulations?
Yeah.
Yeah. So at the moment, it's the building as it stands does not conform with the building regulations. Is that fair to say?
That's correct.
Right. Okay, Mr Ferguson.
Thanks for clarifying that, ma'am.
Do you have a follow-up question on that?
Yeah, just a follow-up point on that. So, Mr Earley, as far as I understand, I accessed the bin store and the refuse chute in question today, and it's just categorically untrue that it's not accessible. It is most certainly accessible.
Sorry, the refuse store is...
The bin store and the refuse chute, ma'am.
Mr Earley, have you said it's inaccessible?
I've never stated that, no.
Mr Earley, you just told us that for firefighting purposes and fire safety purposes it was inaccessible.
No, in terms of the firefighting regulations, for access for firefighters.
So in what way is it inaccessible in your assessment?
Sorry, Mr Ferguson, if I may interrupt again, I understood Mr Earley to be giving me the kind of heading in what we tend to call the building regulations. It's now called the technical standards. I understood him to possibly my own background knowledge, and I should have made it clear. I understood him to be referring to the heading in the Technical Standards Manual, which says, as a generality, access for firefighting. Am I right about that, Mr. Early?
Just to expand, it's the risk of smoke in the event of a fire within the firefighting access stair. So if the building isn't redeveloped, nobody's going to close the building down because it's a current situation. But in redeveloping the building, we would have to examine the current standards.
Thank you, Mr. Riley. So, as far as you're aware, in your efforts for the planning of this feasibility study, that particular risk was not assessed for building 30 to 50, is what I take away from that. Is that correct?
Could you repeat the question, please?
So the particular risk to which you refer, so presumably smoke and inhalation or smoke exposure in the event of a fire in the building, from what you've just told me there, it seems apparent that that risk has not been assessed in your planning. If that's incorrect, would you be able to
Mr. Ferguson, I really don't think we can begin to take that from what Mr. Early has said. Mr. Early was being questioned about why it was necessary to redesign the refuge chute. He's not been asked about risk assessments, and it's not been suggested in his evidence that he's ever been asked to carry out a risk assessment. So I don't think that is a question for Mr. Early.
No problem. Thank you, Matt. All right, Mr. Early, moving on. The entry below that for paint close, which is presumably the entire interior of either building, as we discussed earlier, has a quote of £5,000 in order to carry that out. Do you know what would necessitate an estimation such as that for a costing of £5,000 to paint the close?
Well, if we can maybe take it a little bit shorter than that, Mr. Ferguson. £5,000 for painting the close in Block 2, do you consider that to be a reasonable estimate, or is it inflated in any way?
I've no reason to question the figures compelled by Langmuir and Hay, because they have vast experience in this type and scale of project. And the numbers they are quoting are taken from recent similar projects, tendered.
Thanks, Mr. Early. In reference to that, any of those similar projects that you're aware of, would you be able to tell me any of those projects?
Of course not. I didn't.
I'm ruling
produce
that.
the figures.
Sorry, Mr. Early. I'm ruling that question out of order, Mr. Ferguson. We're not roaming through all the close painting that's happened under Mr. Early's knowledge. We're focusing on this building, if you would, please.
No problem, ma'am. Yep. So, yeah, the next entry says Vici floor. Would you be able to explain to me what that means, Mr. Early?
It's a resin application applied to the surface of stairs and landings.
Okay. Thank you. And are you familiar with how much that costs in any capacity for any planning that you've done?
I'm not aware of how much that costs per square metre now.
Okay. So, just to
all of these costs, as I do in all projects, I rely on the experience and knowledge of professional cost consultants.
I mean, for what appears, in the absence of any specialist knowledge, to be some form of resin, £7,500 to me seems like an excessive amount of capital investment that also doesn't have a clear purpose.
Yeah,
in the
Mr.
planning.
Ferguson, that's really evidence that you can give yourself. I think Mr. Early has answered the question so far as he can. He's made it clear that in these circumstances he would rely on the cost consultants, QSs, and I think that's where we should leave it.
Okay, well, thank you. So, an important distinction here between the first entry we discussed, new front closed door, which has a valuation of £2,500, and door entry, which has a figure of £4,500. You stated that the excessive cost for a new front closed door could include the electrical work done to the door, which would presumably be the door entry
No, I didn't
system.
say that. I said, in the past, I have experienced a situation where a functioning front door had to be replaced because it couldn't accommodate the electronics required for a door entry system.
Yeah. So, document EDC, as it's in front of you now, Mr. Early, which of those entries to you would seem to suggest more that it refers to the electronics repair of a similar project as you described?
Which of the two numbers, front closed door or door entry system, refers to the electronic door entry system? Is that the question you're asking?
They're two separate entries. Which one? Yeah, that's what I was saying.
I would guess that the electronics for the door entry system are allowed for under the door entry.
Thank you. So, again, just to reiterate, it's not clear to you, or myself, for the record, from the planning document, what new front closed door £2,500 is costing for.
Is for a new front closed door.
Yeah. Okay. Close lighting. That's obviously an important one. I've brought this up myself separately in documentary evidence submitted in the form of images to EDC and to the DPEA, that the lighting in the close is inadequate as a result of their lack of maintenance. The costing here, £3,000 for close lighting. In the event that Block 2 were to be refurbished, what, to the best of your understanding, would close lighting entail?
Close lighting.
Would you be able to expand on that?
A lighting system to provide safe access and egress from the common close.
So the existing lighting system, which consists of several light bulbs, some of which work and some of which did not at the time the evidence was submitted to the DPEA, were someone to repair that lighting system, i.e. replace the small number of light bulbs that were broken in order to make it functional for the safe ingress and egress from the property, that would probably fulfill the definition of close lighting, wouldn't it? That would be an adequate system for that.
Can I try to explain how costs are considered at the feasibility stage of any project?
Please.
The cost consultant is having to estimate costs based on limited information. There's been no electrical survey carried out to the common close lighting, for example. So just say the option to refurbish the properties was accepted, and then suddenly the costs were double what the cost consultant had said they were going to be. He has to try and look at a balanced view of what may or may not be required for replacement based on limited information. So the entry for close lighting, for example, is something which, when it went to a detailed stage, the next stage of design, RIBA 3 or 4, there would be a proper assessment done of the close lighting to check if it was satisfactory in terms of current regulations, and that the local authority's lighting department would continue to maintain it following the work. So all of this information is based on the information available at the time, which is limited.
Yeah, thank you for that answer, Mr. Riley. That clears that up a lot for me. So just to confirm, to the best of your awareness, the part of the reasoning for such a costing like that was that no inspection was in fact carried out on the common close lighting, so there was a lack of information.
Mr. Ferguson, you don't. When you're asking a witness a question, it is unhelpful and a waste of time to try and to put words in the mouth of the witness when you're summarising his answer. It doesn't wash with me.
Yeah.
So be careful about that.
Okay, ma'am. The entry following close lighting, Mr. Riley, is smoke alarms ETC, which has a value of £2,500. Now, approximately, what would you say a smoke alarm costs?
I'm not a mechanical and electrical engineer. I wouldn't know what the cost of specialist smoke alarm system for a common escape area is to comply with the regulations.
Yeah.
Mr Ferguson, I mean, I think Mr Early's made his position clear. He's an architect. He relies on the advice of cost consultants, quantity surveyors, to help him get the costs right. He's mentioned that that in many cases there's a number of stages at which this can be done with greater or lesser accuracy. I think that might be as far as Mr Early is able to take us. But you are questioning such things as the cost of smoke alarms and other nuts and bolts of the process of fixing a building. I'm just wondering if from that, at that kind of level, we may be able to get better evidence from another witness. I'm wondering about Mr Miller, Ms Hamilton. Would Mr Miller be able to help Mr Ferguson with the actual kind of cost of a smoke alarm and that sort of level of detail, or?
He may be able to. That's something that we can. That's certainly something that we can explore with him.
Yeah.
Can I just commend that the cost of a smoke alarm is not relevant to the cost of a smoke alarm system within a common stairwell.
A fair distinction. You're talking about a wired-in system, aren't you?
Yeah.
Yeah.
Ma'am, what I would say is these are the figures which are in front of the inquiry. Obviously, Mr Ferguson is entitled to explore them, but there are no alternative figures before the inquiry, and evidence has been given as to the experience of those that have prepared the figures. Mm. And that's the basis on which we are proceeding.
Yeah. Yes, I take your point, Ms Hamilton, but you know, it's often the case that at a certain level of housing works, the other side of the dialogue, if you like, the owner is entitled to say why does that it's going to cost as much. So, and I don't think that does actually at that sort of level. I don't think the absence of a technical alternative is a concern the way it would be in other circumstances. So I'm not ruling that these questions is out of order at all. I'm just wondering whether we might get better information from somebody who's closer to the actual, you know, if you like, more routine work of rehabilitating a block. And I'm wondering whether Mr Miller would be better. But it doesn't look like we know. Is that right?
Well, I can obviously ask him about that. Mr Miller has experience in maintenance and repairs and investment, but we can test that with him.
Mm-hmm. Just don't want to lose the opportunity.
It's not what he's here to speak about in terms of giving a detailed critique of figures prepared by someone else who has experience to produce those figures.
Well, carry on, Mr Ferguson, at the moment. I'm a bit concerned about getting down to the level of detail beyond which Mr Early is unable to be of assistance, and that's not a good use of inquiry time. That's really what's concerning me.
Yeah, no, I absolutely agree, and to your point as well, Ms Hamilton. So, Mr Early, really just to kind of draw together what I'm trying to say from these costings, there is an overall approximate costing of £46,000, which is itself an estimate by Langmuir and Hay, which allows £50,000 for the common stairwell to be repaired. For various estimated costings for things such as access scaffolds, aluminium base angles, substrates, fungicidal wash, etc. in the same document, there's an estimate cost there which allows £125,000. My question to you, Mr Early, is that having not seen how these costs were worked out, you're relying entirely on the, as you put it, the experience and the competence of Langmuir Hay to produce accurate costings as they would relate to this CPO.
What you said immediately before that final question, could you repeat that? You were talking about costs for scaffolding and the like.
Yeah, there's a portion of this document which has costings for, so for example, asbestos removal allowed £20,000. The particular point in question states allows scaffolds as an area of 898 metres squared and allows £26,940 as an approximate cost for that. There's a whole list of things below that, and again, not to get into detail with them because I'm aware that you likely won't be able to answer that. Effectively, are you relying on the information provided to you as a planner by Lang, Muir and Hay to make your assessment of how these costs would relate to the relevance of the planning process and the CPO process?
Well, in terms of the costing of the feasibility study options, I rely largely on Lang, Muir and Hay to produce the costs. I've worked with them in many projects, and their record in terms of estimating costs, creating a cost plan and taking it through to conclusion with proven skill, then yes, I do rely heavily on them. That's a normal part of the construction process.
Yeah. Thank you for that. Just kind of moving away from document EDC 131, in your recognition, Mr. Riley, in paragraph 2.3, subsection 2.3.3 and 2.3.4, subsection 2.3.3 contains option 3, which is demolition of blocks 1 and 2. Specifically, so as to minimise costly services and sewer diversions, and 2.3.4 is option 4, which would include presumably more costly services and sewer diversions, as was touched on yesterday in questions to Mr. Brodie. Can I ask you, are you responsible for producing the wording of option 3 and option 4 in the feasibility study, document EDC 56, the options analysis, which has been produced by the Council? Are you responsible for the wording of option 3 and option 4 in that document?
So you're referring to the precognition and also to EDC 56?
I'm referring to EDC 56. I'm referring to the precognition just for ease of understanding.
So is the question relating to which of the documents or both?
Well, it's in both. It's in your precognition as 2.3.3 and 2.3.4, and it's in document EDC 56 as proposed option 3 and proposed option 4.
Ms Ferguson, could you just focus in on which descriptions of the options in the feasibility study you want to look at in particular?
Yeah, certainly, ma'am. One moment.
So yeah, in EDC 56, on the page called Options Strategy,
Yeah, that's correct, Mr. Riley.
Outlines the 4 options, and yes, I'm responsible for the text on those pages following discussion with the design team and the client.
Thank you. So just to confirm, for option 3, it is your opinion and your wording that demolition of both existing blocks should be replaced with new, modern, high-quality buildings located so as to minimise costly services and sewer diversions. You produced that wording in that assessment, is that correct? Thank you. And the same for option 4, you produced the wording for option 4 on the same page?
Correct.
Okay. You related yesterday to Mrs. Ferguson that you had at some point visited Block 2 in order to undertake some form of assessment related to your own planning considerations. When did you visit Block 2, Mr. Riley?
I couldn't give you a date. Early on, when following our commission, I would guess.
Could you give an approximate month or year?
I couldn't give you an approximate month, no.
Mr. Early, the document was produced in 2018. Is it helpful? It was February, I think, 2018. Would it help to sort of count back
It would be in the second half of 2017 then, if that's accurate enough for you.
Second half of 2017. Right.
So, do you know who was with you when you attended Block 2 to carry out that assessment? Or were you alone?
I was with somebody else from my office, and well, I visited the site several times with various people,
So
including the cost consultant and asbestos officer from the council and the structural engineer at various times.
and to
May have been
confirm,
my own also.
that's building or Block 2, which is the properties comprising 30 to 50 Nithsdale Crescent that you visited several times with several people. Is that right, Mr. Ellie?
Yes.
Okay. And during those visits, precisely what parts of the building did you enter?
The common close up to the top, walked around the building and accessed one or more of the flats owned by the council.
In which flats were those?
I couldn't recall.
Okay. So how could you confirm that they were owned by the council?
Because that's the council arranged access for me.
Okay. But you don't know who actually owned the particular flats which you entered?
I assumed it was the council.
Yeah. So during these visits, Mr. Early, were you aware that not all of the properties in Block 2 were owned by the council?
Yes.
And how were you aware of that? How had that become known to you?
The council had advised us there was 5 private owners, I think.
Who was that at the council that advised you of that?
Can't remember.
I'm not sure why this is helpful. It's absolutely clear that most of the people involved in this knew that there was owner-occupiers. So why is this important?
We'll just get to that then, ma'am. So essentially, you've made an assessment here.
Mr. Ferguson, why are you asking who told Mr. Early which flats about the owner-occupiers? Why are you asking about that?
Ma'am, I believe it's relevant to provide context to the point that I'm trying to make here, which is that there's enough detail. Mr. Early can recall what parts of the building he went to, and they went to that building, and roughly whom he went with, but not which properties he accessed or who he was with when he accessed those properties. I find that hard to believe. I believe it's disingenuous.
Well, whether you find it hard to believe is neither here nor there. The evaluation of the evidence is a matter for me. What I'm asking you is, why are you asking Mr. Early how he knew which flats were owner-occupied? Why are you asking about that?
It's relevant, ma'am, because there's no reason that the council that I can think of would have relayed that information to Mr. Early. So I'd just like to know who was responsible for relaying it to him.
Sorry, you're saying there's no reason. Your proposition is there was no reason why the council should make Mr. Early aware that there were 4 flats in this block that were owner-occupied. You're saying there was no reason for that?
I'm saying that the reason for that is not apparent to me, ma'am, which is why I asked who at the council had told Mr. Early that.
I don't agree with you that this is an important point, Mr. Ferguson. To me, it seems perfectly obvious that if Mr. Early was being asked to carry out an options appraisal, he should be made aware of the ownership situation within the building and the land he was being asked to study. It's absolutely apparent, it's one of the basic elements that he would, I think quite properly, have to take into account into his option appraisal. So that's not helpful. Could you move on to another line of questioning, please?
Absolutely, ma'am. So, Mr. Early, essentially, you've assessed that the two of the 4 options that you've put forward, option 3 and option 4, you've assessed that demolition of both blocks, both existing blocks, that is block 1, 8 to 28, which has now been demolished, and block 2, 30 to 50, Nithsdale Crescent, were feasible options. Do you still believe that to be the case?
Are they both feasible options?
Yes.
I think all 4 options are feasible options.
And in 2021, obviously 3 years from approximately when this assessment was made, you still believe that to be the case?
We'd run the costs again to see if it was the case, but I'd imagine it was still the case.
Yeah, certainly. Just the cost aside, the feasibility of those options.
I've no reason to think any one of the 4 could not be delivered, apart from the fact that block 1's down.
Yeah. So, in document EDC 43, Mr. Brodie explained to us yesterday that while compulsory purchase was an option that was available to the council, it wasn't particularly being promoted or pursued at that time, just that they'd taken consultation on it. Can I ask then, Mr. Earley, why, when it was known to you that there were properties in 30 to 50 Nithsdale Crescent which were not owned by the council, and there was not a CPO process to take ownership of those properties, that you considered it feasible that private properties within that building would be demolished?
It's not my position to make decisions like that. I'm just asked in terms
It's your
of
assessment, Mr. Earley. I'm asking why you've made it.
Technical assessment is that it's feasible.
And what's feasible about demolishing 4 properties you don't own? Who is it a question for, ma'am?
Mr. Brodie, and you asked it.
I asked it to Mr. Brodie, and I was told it would be better directed to Mr. Earley.
No, not to my recollection. What you're asking about is one of the decision-making process to promote the CPO. Mr. Earley is here to speak to the technical aspects of feasibility, not to such policy decisions.
Yeah, that's correct, ma'am. So the policy aspects aside, you were aware there were parts of this property that could not be demolished because your client did not own them?
I was aware that there were properties not owned by the council, yes.
Yeah. So therefore, it would not have been feasible to demolish those properties because your client did not own them?
It would be feasible to demolish them if they had agreement with all parties.
If the properties were owned by the council, but you've said you were aware that they were not owned by the council.
I was aware, yeah.
Yeah. So therefore, that would have been infeasible, wouldn't it, Mr. Earley?
No.
Again, Mr. Ferguson, Mr. Earley has made it clear that his function was the technical feasibility, not matters of the legality or the policy aspects of which and how the council would pursue the next option. So I'm ruling that line of questioning out of order.
Okay, ma'am. In paragraph 2.4 of your precognition, Mr. Earley, it's titled Design Team. The first sentence of that paragraph states Langmuir and Hay were appointed as quantity surveyor cost consultant, and their role in the feasibility study was to produce approximate work costings of the options that had been developed for consideration. Who appointed Langmuir and Hay?
I appointed them as part of my design team.
Yeah. So it was you personally or Coulthard Earley appointed them?
Coulthard Earley.
Yeah. So the same paragraph goes on to state that these costings, along with the architectural, and structural and civil engineering design information, would then inform the degree of preference for each option. As we've just gone through there, it seems apparent that as things stand in 2021, and highly likely when they were made in 2018, that those costings were not reflective of what each of those systems proposed would actually cost. Do you think it's fair that such costings would inform the degree of preference for options such as option 3 or option 4?
No reason,
Mr.
reason to think
so
not.
Mr. Earley, I just want to double check exactly what Mr. Ferguson's saying. It's another one who is not reading my wife's questions. I think your question is predicated on your contention, Mr Ferguson, that the costings are in some way inadequate. Do I understand that correctly?
Yes, ma'am.
So the first thing to establish is whether Mr Early accepts that proposition. Do you accept that proposition, Mr Early?
Proposition that the costings are inadequate?
Yeah.
I don't accept that, no.
So Mr Early doesn't accept the predication on which your question is based, so you'll have to recast your question.
Mr. Shirley, you make reference to similar projects in the planning document, EDC 056. It's based on similar projects. And yet, in evidence submitted by EDC, there appears to be no similar projects to the proposed development at Nithsdale Crescent. Would you be able to tell me if there are any similar projects that relate to this development as they've been put forward in your plans?
You're talking about in the Eastern Bartonshire Council area, across Scotland, in Glasgow?
Just any that you are aware of in any part of Scotland.
Examining existing buildings and then demolishing them to put up new built housing.
Yeah, but buildings and projects in particular that are similar to those described at Nithsdale Crescent.
Well, of course there are many projects which are similar across Glasgow.
Mr. Shirley, I've not seen any of these projects in any of the council's evidence, so I'd just like to ask to help clarify their point.
Ma'am, I think we've already spoken to Mr Ferguson about this reference to other projects in relation to the costings.
Mr Early, in his recognition, has made reference to his knowledge being derived from other elements of his experience, and to that extent, I think Mr Ferguson's entitled to explore some level of that experience.
But let's see where it goes.
Okay, Mr Ferguson, you were asking Mr Early about what other projects he felt to be similar.
Yes, ma'am.
Are you able to, what projects of a similar nature come to mind, Mr Early?
I've worked on many projects similar to this. I can send you a list if it helps.
Well, no, we have. you can't do that. I mean, let's see how we can get a handle on this. You have mentioned in your recognition that you have a lot of experience of, if you like, the public sector environment, and you've worked on rehabilitation of housing a considerable period. Is that you've considerable experience in the rehabilitation of older housing?
Yes.
That's fair to say. Now, what we're talking about here in block 1 and which is gone, and block 2, are you familiar with similar buildings like that in your past work?
Are you talking about buildings of the same plan form and shape?
Well, I think if we can take it to a very general level, Mr. Early, I mean, something about that size and shape and of that age and era.
That age and era, but not that particular shape. More linear projects.
Sorry?
More linear.
More linear projects?
Yeah.
When you say more linear, do you mean like blocks of housing and that sort of thing?
Yeah, usual, yeah.
So are these blocks actually relatively unusual from their category?
I wouldn't say they're unusual, but I haven't had specific experience of buildings of that shape.
Of that shape, of these two blocks?
Yes.
So this is actually these are blocks that you haven't as such encountered before.
Not personally. I couldn't speak for others in the company.
No, but from well, you're our witness, Mr. Early.
Yeah.
It has to be you. So these blocks that we're looking at are relatively unusual, very unusual. Which of the two?
To me, or in general?
I think from your point of view.
Well, from my point of view, they're unusual.
They're unusual. And is that just because you haven't encountered them before, or are they particularly idiosyncratic?
I haven't encountered them before, but I couldn't say how frequently they're repeated across the country.
Right. But you haven't encountered this particular species before?
No.
Right, okay. All right, Mr. Ferguson, I don't know whether that helps or not, but...
Yes, certainly, ma'am. That's more or less exactly what I was getting at. So thank you, Mr. Early, for that. And just to reiterate on that, so from your precognition, you have over 40 years of experience in your chosen field, and you've not encountered any buildings that are similar in construction or shape or otherwise to Nithsdale Crescent.
Similar in construction, but not in shape.
Okay. In section 2.7, or paragraph 2.7 of your precognition.
Sorry, plain interference, Mr. Ferguson. Which number?
2.7, ma'am.
2.7, thanks.
It states, for new build options 3 and 4, the new build housing elements were appraised using cost data. I assume this cost data is the information that's been provided by Lime and Hay, is that correct?
Correct.
Yeah. From current similar projects for similar house types to give approximate units per cost. Now, we've just clarified there that you're not aware of any current similar projects for similar house types to those proposed for Nithsdale Crescent.
Okay.
Why have you said that in your precognition? What are the similar projects that you refer to?
Are you talking about 2.7?
Yes.
The similar house types are projects recently completed for Eastern Bartonshire Council.
Would you be able to give us any examples of those?
It's a similar block of flats at Kilmerdinny for the new build 3-storey part, and terraced houses there too. And also other sites across the area.
Okay. Thank you. So it goes on to say, estimates were added for demolition of existing structures, and extra amounts were added to account for abnormal costs which had been identified. In the main, these being services diversions. I couldn't actually see any evidence of those demolitions costings. Mr. Early, do you know where they are?
Are these the costs that we see in the options appraisal, Mr. Ferguson?
I don't know, ma'am. That's what I'm asking. I can't see them anywhere.
Okay, I think that's what you're asking Mr. Early to deal with. Am I right, Mr. Early? The references you make in your precognition 2.7, you're taking us through the feasibility study, aren't you? Yes. Right. So I think the costings are the ones that you would be reporting to council. Am I right about that? So that's 8.4, is that right? The feasibility study? Okay, Mr. Ferguson?
So yeah, just approximately, is there a pound figure for that demolition cost that you identified or was related to you by Lime and Hay?
Repeat that again, please.
What is the approximate cost of the demolition of existing structures as far as you're aware, or that was related to you by Langmuir and Hay?
120,000 per block.
To demolish the block?
Yes.
In section 2.8, or paragraph 2.8, Mr. Ridley, stated that for refurbishment options 1 and part of 2, more detailed costings were carried out. Would it be right in assuming that those costings are the elemental cost plan that was referred to earlier? That's document EDC 101.
No, that wouldn't be correct. The elemental cost plan relates to the design for planning application.
Yeah. And which document is that in evidence?
EDC 101.
Yeah, so that's what just... Yeah, EDC 101, as I have it in front of me, Mr. Early says, Eastern Barnshire Council, Nithsdale Crescent, elemental cost plan. Is that the same for you?
Yes.
Yes. So in terms of design planning, or what you just mentioned there, where is that reference, the costings for that?
Say that again?
You just mentioned design planning or something of the like. Where's that mentioned in EDC 101?
I don't know what you mean.
What's that?
I think Mr. Early said that the figures were prepared for the purposes of the planning application.
That's correct.
Yeah, so just to clarify, Mr. Early, that was my question. Is EDC 101 the more detailed costings to which you refer to in paragraph 2.8 of your precognition?
Are they more detailed?
Well, Mr. Ferguson has pointed out that in 2.8 you say, for refurbishment options 1 and part of 2, more detailed costings were carried out.
No, this is
that,
this has nothing to do with.
Yeah, this is option
2.8.
4, Mr. Ferguson. 101 is option 4.
Okay. Are there any costings for option 1 and 2 that have been submitted to evidence?
The more detailed costings are the lists which are appended at the back of 131.
131. Yeah, that's what I was looking for. Thank you, Mr. Allen. So, I've had a look through these a couple of times during this process, these costings. I'd just like to clarify a couple of things with you. Internal improvements is the first section of that cost plan. Yes, ma'am. It's at the back of 131. Eastern Barnshire Council refurbishment to flats, Nithsdale, Bearsden, feasibility cost. So, yeah, Mr. Early, in that document it states that for bathroom fittings, that's subsection 1.2 of section 1, internal improvements. Bathroom fittings, which is described as bath, water closet, WHB, whatever that is, shower, screen, and anti-scald valve. One of those will be required in the refurbishment of the building, and that will cost £2,000. Can you tell me why it would be necessary to include new bathroom fittings in a privately owned dwelling in order to refurbish it, if you've not seen the inside of those privately owned dwellings?
I've already stated that these costs are based on the specification for the council flats, if they were refurbishing.
So what you're saying is, as far as you're aware, Mr. Early, the council had no intent at the time to refurbish privately owned dwellings?
I can't hear you for the silence, sorry.
Can you hear me now, Mr. Riley?
Mr Ferguson, I have warned you already about recasting a witness's answer in your own words. What I'm interested in is what the witness actually says, not your version of it.
Yeah.
Mr. Early, Mr. Early clarified that the costings, to his understanding, are based on the cost of refurbishing a council-owned flat. You've extrapolated from that a contention that means the council didn't have any intention of refurbishing owner-occupied flats. The evidence from Mr. Early doesn't bear that contention. So restrain yourself. Don't. It's not helpful to me. It means I have to take an unhelpful note. So just I'll be concentrating on what the witness actually says in response to your question, not your version of it.
So, Mr. Riley, in the same paragraph, 2.8 of your precognition, states this applied to internal works to flats, works to common stairwells, and works to external building fabric. For the roof element, costings were derived for previous quotations obtained by the council. Are you aware of what these quotations are, or who they were from, or for how much, in terms of pounds, what those quotations were that were obtained by the council for the roof?
Yes, there were quotations received in 2008 for the same blocks at £116,000, which has been extrapolated using trade price index to 144,000 current day.
Thank you.
Mr Ferguson, that's us coming up to 10:45. Have you got much more for Mr Early?
Not much, ma'am.
Well, what would you say? 5 minutes, 10 minutes?
Yeah, we could probably clear it all up in 10 minutes.
Yeah. Well, I think perhaps what we'll do is we'll take a break now for just a few minutes. I think we'll resume at 10:50. So we'll take a sort of 8-minute break, comfort break, how shall we call it, and then you can resume your questioning after that. If you would perhaps use the break to think about what questions are really important and focus on those. Okay, right, we'll rise until 10:50.
3, paragraph 3.4 in the related subsections 3.4.1, 0.2, 0.3, 0.4, 0.5 of your precognition states that it refers to the scheme, which I assume is document EDC 61. Is that correct?
Sorry, where are we again? 3?
Yeah, 3.4, ma'am.
3.4. And what did you say? What, sorry, please repeat your question.
So it states there that the scheme aims to produce an environment. Is that document EDC 61 you mean when you refer to the scheme?
It refers to option 4, which was the option the council chose to promote. Oh, sorry, later on, yes, it's the planning application scheme.
And is that the planning application which is, as I understand it, currently on stop the clock, so there is no actual planning permission for the development at the time, is that correct?
There's no planning permission.
No. So basically, Mr. Riley, this says the scheme aims to produce an environment which is distinctive yet fitting for its location. Could you define what you mean by fitting? Fitting for its location. What does that mean?
It's designed to a scale and style that would be appropriate to the surroundings.
Okay. Paragraph 3.4.2, you state, it's safe and secure for residents and neighbours alike. There's nothing I've seen in any evidence submitted by EDC or offered by yourself to suggest that the current block, which is block 2, 30 to 50 Nithsdale Crescent, is unsafe or insecure for residents and neighbours. Is there anything you'd like to offer at this time that's contrary to that?
Are we talking about the existing situation now, or
what I'm asking Mr. Early is, to the best of your knowledge, is there anything that suggests that 30 to 50 Nithsdale Crescent is unsafe or insecure?
I think everyone in this room has been talking about antisocial behaviour and problems within the property, so I can only take it from people with knowledge of the buildings that it has been unsafe and insecure. I have no personal experience of that.
No. And yet it's included in this scheme. Paragraph 3.4.4 states, creates a sense of place of which residents will take ownership. Mr. Early, would you be able to explain to me what you're referring to there? We have ownership now. We have a sense of place. This new development will not offer that. So what I'm asking is, what does that mean?
The creation of defensible space, the relationship of the buildings to the street, promotes or encourages residents to take more responsibility in terms of the property immediately in front of them and to the rear of them.
So are you suggesting that current residents are not responsible for their properties? Is that what you're saying?
I'm suggesting that in terms of design guidance and good practice, the proposal for 26 houses does just that. I haven't made any reference to what existing residents do.
But it seems to suggest that when it says residents will take ownership, that they're not taking ownership now. Is that what you're suggesting?
It doesn't suggest that.
So what do you mean they will take ownership?
It doesn't suggest that.
That's not what I'm asking. What do you mean by they will take ownership?
I think we've examined this topic, and I don't think I really require any further evidence on it.
Okay, ma'am. Moving on. Paragraph 3.4.5 is easy to get around in welcoming. The current buildings, which I'll accept, given the common stairwell which you've examined, are inaccessible. But would you not say, Mr. Early, that they are inaccessible by design, i.e. when they were built by the council originally, that there was not accessibility built into those buildings in your experience of a planner?
Could you repeat the question again, please?
Do you think the current buildings are accessible at, well, block 30 to 50 and block 8 to 28, which no longer exists?
They're accessible.
So
yeah, they're accessible.
They're
In terms
accessible.
of getting to them.
But in terms of wheelchair accessibility, it'd be quite easy to get to the top of that building if someone was disabled, for example.
My recollection is there's steps to the front door.
Yeah. Was there an access ramp?
Was there an access ramp? Is there an access ramp?
When you went to the property, was there an access ramp?
I don't recall.
But you remember that there were stairs?
Yeah.
Okay. Paragraph 4.2 of your recognition, you state that the inherent issues of security, ownership and management which are generally associated with point blocks sitting in communal open space, are usually considered too difficult to resolve. Now, we've already established, Mr. Early, you're not an expert in security, so again, I'll ask you to specifically confirm now what has led you to the assessment that any antisocial behaviour issues, of which we've yet to see any real evidence from the council, could not be resolved without demolition of the properties, as you've stated here.
The proposals for retention showed a degree of private space around the existing blocks, if they were being retained, to try and provide private drying areas and gardens and better defensible space. So I think it could be improved if the blocks were retained. And we've shown that that can be done to a degree.
What issues in particular, when you refer to the inherent issues of security, and I'm being specific, I'm not talking generally, specifically what are you referring to in terms of issues of security here that are too difficult to resolve? Because this is a material consideration that's been promoted as one of the main factors initially for promoting a compulsory purchase.
When there's no defensible space around a building like that, it's easy for anyone to come up to the face of the building and to, without the knowledge of the residents.
Mr. Early, your proposed plans don't change that. It's also easy to approach those buildings as you've laid them out in your documentation and drawings.
Again, Mr Ferguson, we really have examined this topic previously, and I'm not sure that you're adding anything new to what's already been reviewed, these questions.
Okay, ma'am, thanks. Just one more question on that, Mr. Early. So, would you say that that's an inaccurate statement?
No.
That there are inherent issues of security when you can't describe any of them?
If you read the Secure by Design document that's been referred to, it mentions that permeability creates more crime. The more permeability, the more crime. So the the basics of good design in terms of security promoted in that document do not exist at all around those blocks.
Okay. So finally, Mr. Early, I'd just like to ask you in paragraph 5 conclusions, in subsection 5.1, it states, although I have not been directly involved in the decision-making process regarding which of the 4 options presented should be pursued, it's my professional opinion from experience gained in numerous similar redevelopment programmes that option 4 offers the best opportunity for a successful housing solution for the local area, community and future residents alike. Can you explain to me which, if any, as we've already covered, but just to clarify, any of these numerous similar redevelopment programmes you're referring to here?
As I said, I could send a list. We've been involved in projects across Glasgow, redevelopment of...
Yeah, for example, your firm, Coulthard Early, has been involved in the development of 1 Highland Avenue, hasn't it?
Pardon?
Would that be one of those projects that Coulthard Early has been involved in?
It's not relevant to this particular case, no.
It's not, is it? It's not similar at all. And in fact, I struggle to find any of the developments that I can see that you or your firm's been involved in that are relevant to this. So that's why I'm asking. It says from experience gained in numerous similar redevelopment programmes. Which programmes?
Various developments in Bearsden and Glasgow.
Yeah. So would you agree
Easter
that's...
House in Glasgow. Easter House. Greenock.
Greenock, sorry.
Greenock.
Is that Greenock? I can't hear you.
Greenock.
Greenock, yeah. Is that part of Glasgow?
No.
Bearsden, Easter House and Greenock, are these the 3 that come to mind as comparators for this project? from your own experience? These are the kind of similar schemes that you're aware of?
Similar schemes, yeah.
Yeah. So Arden, can you give me a name for the Arden scheme that you're involved in?
I can't.
And how about Easter
Sorry,
House?
can you give me the client name?
Well, yes, client name might help if that's available.
Glen Oaks.
So is that a housing association?
Yeah.
Is that a housing association?
Correct.
But you can't remember the address or the name of the scheme as
No.
such? Easter House, could you give me a street name or a project name?
Just Blair Tarmac Housing Association.
Blair Tarmac. And how about Greenock? What was it? Can you give me a street name or a project name for that?
No. It's
Why do these ones come to your mind as being similar? What's the key similarities between this project we've got before us now and these similar schemes that come to mind? What's the main element of similarity for you?
It's to do with the refurbishment or demolition of older housing stock.
Right. Refurbishment and demolition of older housing stock.
And/or.
Sorry?
And/or.
Right. And can I just ask, your involvement in these projects, these three that come to mind, was that right the way through? Was that just at feasibility stage? Did you take these projects forward as architects through to conclusion?
Yes.
Right. So these are slightly different cases in that you were fully involved in the redevelopment from the beginning to the end.
Can I add Mockinhill in Greenock, which has come to mind?
Sorry, say that again.
Mockinhill in Greenock.
Mocklinville?
Mockinhill.
Mockinhill.
M-A-U-K-I-N.
Greenock names. Spell it for me.
M-A-U-K-I-N-H-I-L-L.
K-I-N-H-I-L-L. Mockinhill. Right. But what I was asking you was, these are projects that you would see you would take right the way through to a conclusion as architects.
Yes.
So, on one interpretation, you would know more about these than you would about this one, because this one is still, so to speak, on the drawing board.
Yes.
Right, okay. Thanks, Mr. Ferguson. I just wanted to get a bit more of a flavour about what the Mr. Early's experience base was in his own mind.
Thank you, ma'am, and thank you, Mr. Early, for that. That's basically what I was asking. So, in the same paragraph, it states, option 4 offers the best opportunity for a successful housing solution for the local area. Option 4, Mr. Early, is, in fact, a more expensive option and therefore obviously entails a greater financial risk. Why would that be the best opportunity, and I'm using a specific word in here, for a successful housing solution? Why would that be more successful than any of the other options when it costs more money and would therefore incur a greater financial risk?
In my opinion, it's a better housing solution. Simple as that.
So it's an opinion. It's not actually based on any kind of tangible.
I've stated in my precognition that it's my opinion.
Okay. Just one last question, Mr. Early. In the event that this compulsory purchase order is confirmed, do you expect to receive or have already received any notification in the event that that happens that you will derive a further financial benefit on top of that which you've already been paid for the work that you've done for Eastern Bartonshire Council?
Could you repeat the question, please?
Have you been made aware of any future financial benefit that you will derive in addition to the work that you've done for Eastern Bartonshire Council in relation to this project in the event that this compulsory purchase order is confirmed?
No.
No. So you don't expect to do any further work on this project for Eastern Bartonshire Council as a planner?
Mr. Ferguson, I've warned you. You don't. Mr. Erling said no. I don't think there's much you can extrapolate from that other than no.
Okay, ma'am. Thank you, Mr. Early.
Is that you finish your questions of Mr. Early, Mr. Ferguson?
Yes, ma'am.
Yes, it is. Right. Ms. McMillan.
Morning, Mr. Early.
Morning.
My first question is, are you aware that there's any stairs in the apartments of Block 2?
Again, sorry, I can't hear you for traffic behind me.
Are you aware of any stairs internally in Block 2? I'm referring to the block that we were talking about in question just now.
I haven't seen any stairs internally.
Are you aware that there is stairs in some of them?
Yes.
Yeah, yes. Do you know how many apartments have stairs?
8, I believe.
8. You know that they're actually referred to as masonettes and not flats?
Yes.
Yeah. That's why they're, I think, so unusual, as you were saying earlier on.
Mm-hmm.
My next question is, are you aware of any structural problems in Block 2?
No.
No? None? No. Can I refer now to, what would it be, Andrew? I'm reading this from, sorry, excuse me. Well, yeah. Sorry. The response to objections, and it says, the type of construction used is known to have problems.
I'm sorry, Ms. McMillan, you'll have to help me. What do you mean, the response to objections?
This is what it's saying here.
Yes, I know. I need to know what it is you're looking at.
Right, that's what I'm saying.
Is it? You said response to objections. Is it one of the council's statements of case, or is it the letters that were written to the objectors?
It's a letter.
Right. And was it the letter that was written to yourself?
Well, it's addressed to me, but I believe we all got one. It's September 8th, the 9th of September 2019.
Right. Okay, hang on a wee second till we get our hands on that. I think I can find a number. Mr. Ferguson, are you able to assist Ms. McMillan with a number for that?
Ma'am, I'm not aware of which EDC number it would be. It is an established...
I'm exploiting your knowledge, Mr. Ferguson. I'm sorry about that. But
it's a communication from the Housing and Social Justice Directorate, More Homes Division. The contact on that is Michelle McCluskey.
So so it's from the Scottish Government client department, if you like, and it's responding to so it must be part of the preliminary correspondence that arises in these cases where the department asks objectors to state their position. That's run past the council, and then the department in the Scottish Government writes back out to... Is that what we're talking about here?
I believe so, ma'am, but just to clarify, it was sent to FMC solicitors, so it would have been... It's a document that I know is lodged on the DPE's website because I've seen it, but I could not give you a particular number for it or download reference.
Could you give me the date again, please, Ms. McMillan?
Yes, the 9th of September 2019.
Yeah. I'm not sure that particular letter is before the inquiry. It's obviously... I don't think Mr. Early knows about it.
Would it be helpful for me to give it to you, ma'am?
No, I don't.
No. to show it
I
to
think
you?
what we'll do is we'll approach it on this basis, Ms McMillan. You want to take a point from it. So
Yes, okay.
What I would
This
like
is
you to
what I
do-
was actually
What I
wanting
want
to
you to do
speak
is to
about
read
last
out
night.
the bit of the letter that
Okay.
you want Mr Early to comment on.
Yes, okay, Mr. Ellis, sorry about that. It says,
Oh, right.
EDC 05 annexed at the back.
So it's back of Mrs Ferguson's letter of objection. EDC
055, EDC 5.
It's annexed to the back of Mrs Ferguson's letter of objection. That's what that's described in your inventory. I'm not sure that we're on the right page.
I think various things have just been bundled together as the objection, but it includes the response. Ma'am, can I check that Mr Early is, when he's not using his mic, that he has it turned off? Because that will help with the sound, I think.
Ms Hamilton, I think, might be right here. I've got a letter to FMC solicitors, and it refers to Mrs Ferguson's objection. It's got quite a long annex to it. And as you said yourself, Ms McMillan, I think everybody got one?
yes.
Right, okay. Mr Early, the letter in question is EDC 005. Have you got it? You all right?
I can see the top half of it,
Well,
but I can't scroll down.
actually, I think we'll see how we go. Just doing it verbally rather
Okay.
than having it in front of us. So, sorry, Ms McMillan. It's always terribly important that we have the right papers in front of us before a question is put. That's what all this is about. Could you please read out the section of the letter
Yes.
that you want Mr Early to comment
Yes,
on?
okay. The authority believes that the property was constructed in the early 70s and the type of construction used is known to have problems. I'm just wondering, I'd just like to know, Mr Early, what you think of that. Would you agree with that?
I didn't write it, but
Sorry, I can't hear you.
I said I didn't write the document. You're asking me if I agree with the statement.
Yeah. But it's regarding construction. I just thought maybe that was your...
Yeah. The construction problems that I know about are listed in my own document, which revolves around energy loss and the quality of internal partitions, the main issues, and
Sorry.
accessibility.
Right, okay. For this question, could I refer to the document then, which is document 4, which contradicts that particular statement? My own document, CMO4.
Got Ms McMillan's productions. Mr Early.
I do, but I'm having trouble opening anything at the moment. Just give me a second. Ian Brodie, can I borrow your technical knowledge, please?
Sorry.
I was asking for Ian's technical assistance with this. Is that okay?
Yes, if you're able to assist Mr Early, that would be great.
Sorry. I was trying to open on Microsoft Edge for whatever reason.
I think I've got a copy of Ms Macmillan's letter. It's the one dated the 21st of June 1999. Is that right?
Correct.
And it's from Eastern Bartonshire Council, and it's addressed to yourself at 48 Nithsdale Crescent.
Yes, that's the one.
That's the right one. Does anyone have a problem with me lending Mr.
No,
Elliott
not at all.
my version?
Oh, yeah.
Now, Mr. Early, you'll need to take a moment with the letter that Mrs. Macmillan wants to ask you about, because it's a page, but it's. Okay, we're getting there. We're getting there. So, what was the question you wanted to ask Mr. Early about relating to that letter?
Yes, I just thought that Mr. Early had said earlier on that, to his knowledge, there was no constructural damage to the block number 2. Are you still saying that, Mr. Early? Would you agree or disagree with that?
Sorry, Mr. Early said earlier that he wasn't aware of any structural damage to block 2. What is the contrary point you want to make, Ms. Macmillan?
Well, it's saying here, the authority believes that the property was constructed, type of construction used is known to have problems. So I just want to know why this has been stated.
Yeah, you asked me if there were structural problems, and I said no. And
You said no?
yeah.
Yeah. And it's saying here that it's known to have problems.
It says where?
On the letter from the response to objections letter. The one that I've read out.
The grant payments.
I think let's have a go and see if I've got what you want to ask
Right,
correctly.
okay.
So listen to how I'm recasting your question. Ms. Macmillan's saying she has a letter which passes on views expressed to the Scottish Government by the Council that say that the block is known to have problems. Ms. Macmillan wants to contrast that with the letter in 1999, which suggests there's
Ma'am, I think it's important Mr. Early have that actual document in front of him so that he can see just the text. That if I'm allowed to bring my folder over, I'm at the right place.
for the letter to Ms. Macmillan. Letter to Mrs. Ferguson. Letter to Mrs. Ferguson with the return to objections.
Okay.
Right. I think I tried to help, but all I did was make things worse, Ms. Macmillan. Could you put your point again, please?
Okay. Mr. Early, have you got it in front of you now? So it's saying the type of, at the very bottom, can you see it, yeah? Type of construction used is known to have problems. And it contradicts the letter, which is document 4 from Eastern Bartonshire Council, saying that there is no problems.
Well, to expand on the first quote, the letter says a type of construction used is known to have problems, particularly in regards to flat roof designs. So I think
particularly as regards, that's particularly yes, but doesn't take away from the fact that it says that the type of construction used is known to have problems.
in my experience and knowledge of the building, there's no structural issues with the building.
Okay, that's fine, thanks. Okay. This brings me on to the last question, which is the question I brought up yesterday with Mr. Forget his name. Mr. Brodie, sorry. And I couldn't find this yesterday, but I found it now. It's on the same page, Mr. Early, just down a bit further. The property is now almost 50 years old. Therefore, it is. Oh, sorry. Right. Just beneath it, the property is now almost 50 years. Therefore, it is the authority's position that the property is well beyond its natural lifespan, and it is not reasonable nor economic to repair or refurbish the property. Housing operators constructing new developments will typically base development decisions on a 30-year lifespan, and this is with the benefits of modern construction methods and materials. Now, it's saying 30-year lifespan, and the masonette is actually almost 50. So my point here yesterday was, and that assumption, then why leave one of the blocks up, which is exactly the same age? That was my point yesterday to Mr. Brodie.
Yeah, I think the structure of the property at Block 2 could be reasonably expected to last for many years to come if it was refurbished.
Sorry, how many years?
Many years to come if it was refurbished.
Okay. So would you disagree with that then, what I've just said, what I've just read off that? Would you disagree with that? About the 30-year lifespan?
What did you say about the 30-year lifespan?
It's saying here, development decisions on a 30-year lifespan. And this actually was, at the top it says, the authority does not consider this to be a valid ground of objections to the order. And that's one of the reasons, because the building has a 30-year lifespan and they want to demolish it.
I haven't read the bit above it, but I would expect buildings to have a longer than a 30-year lifespan. Yeah.
Yeah, I just wondered why this is stated here. I'm not saying you wrote it. What I'm saying is, you know, I don't understand why this is written here about that, about the 30-year lifespan, and also about the construction of the building's got problems when it obviously hasn't. So that's quite worrying for me, that this is just a basic made-up lie. But anyway, that's nothing to do with you, and you have answered your question, but thank you. That's all, thanks.
Okay, thanks, Ms McMillan. Is that all your questions for Mr Early?
It is, thanks.
Okay, Mr Farrell, are you ready to go?
Thank you. Yes, I think so. Good morning, Mr Early, and I'd like to echo Mr Ferguson's thanks for your time here. You have, from your precognition, a vast experience as an architect, and it's very beneficial to have you here partaking in the process, so thank you. To that point...
Yeah.
Thank you. From your precognition, sir, I think it says you have 40 years' experience. Is that correct?
Correct.
So I'm just thinking, from the time that this building was constructed, designed, developed, that probably coincidentally is the time you were undertaking your training as an architect. Is that fair?
Probably.
And in answer to a recent question from Mr McMillan, you alluded to problems with the flat roof. Now, the flat roof on block 2 is of, well, don't let me prejudge. Is there any aspect of the building which is regarded as non-standard construction?
I'm sorry, Mr. Farrell, I'm having trouble hearing you.
So is there any aspect of the construction of Block 2 that can be considered to be non-standard construction? Yeah, you have to turn it off to hear through the thing. So is there any aspect of the construction of Block 2 that you consider to be non-standard construction?
I would say no, not really. There's mineral wool insulation in the cavity, which is unusual. But other than that, I would say it's not unusual.
Thank you. And the flat roof as it was designed and installed at the time of build, whenever that was, there's some ambiguity about that was, when that was, it's, I think in EDC 062, which is the structural appraisal, a date of 1974 is assumed as a conservatively safe date, and it's definitely not the 1972 date that appears in other documentation. And it was after then, and certainly before 1985. But around that sort of time scale, were there any considerations to a flat roof's design life expectancy? What as you were doing your training, what was the feeling for the lifeful use of a flat roof of that type?
Can't really answer that question because it's not anything I dealt with at the time. But I would guess that a flat roof would be expected to last for about 30 years.
Thank you. That's what I expected from what I'd seen. Anything 20, 25 years, exceptionally maybe as soon as 10, maybe as late as 50. But it's been known throughout the life of Block 2. Is it correct to say that throughout the life of Block 2 it's been understood that the roof that's been designed and installed on that block has a life expectancy of around about the figure you just quoted?
I would say that's a fair comment.
So would you expect there to be in place some sort of preventive maintenance schedule for a roof of that nature?
I would expect that to happen.
Thank you. And towards the end of that expected lifespan, which we've now exceeded by decades, would you expect there to be regular inspections and corrective maintenance plans implemented if required?
If there was a factor in place, I would expect that to happen.
If there wasn't a factor in place for a building owned by a council, would you not expect there to be any preventive maintenance schedule in place?
I would expect all the owners to have equal responsibility for ensuring that it happens.
Thank you. Okay, thank you for that. Touching on the time the block was built, and I think before Mr. Ferguson engaged with you yesterday, I was of an assumption, which is always an unsafe place to start. The feasibility study of EDC 56 was your creation front to back with your thoughts, opinions and findings. But I think we discovered yesterday that some, if not much of it, has been lifted from the design brief that the council gave to you. Is that correct?
That's correct.
And in that background paragraph, it talks about a build date of 1972. Do you have any knowledge of when the block was built? Or is that just what was passed to you?
That's just what was passed to me.
Thank you. Mr. Ferguson asked a question relating to knowledge and experience of similar blocks of flats. I think in your question to Mr. Ferguson, you said that you didn't know of any blocks of flats similar in construction to blocks 1 and 2 Nithsdale Crescent. Is that a fair recollection of your answer?
Yes.
Thank you. If we can look at EDC 56, I'll just find the paragraph reference. Paragraph 2, background. Could I ask you to read the first couple of sentences of that paragraph? What does it say?
Mr. Farrell, we can see what it says if you get to the question about it.
It says that it's 2 of 3 blocks, 2 of 3 identical blocks. Do you agree?
To an extent.
To which extent don't you agree that that's what it says?
One of the blocks is mirrored from the other in terms of blocks 1 and 2.
No, that's absolutely true. That's my assertion. But regarding what's printed in the document, do you agree that the document says what I said it said?
I agree it says what it
Mr.
says.
Farrell, we have had a passage of evidence about this, and if something's been covered in evidence before, unless you want to derive something completely different from it, it's much more helpful if we don't hear exactly the same evidence all over again. I think, to my recollection, that the concession was made that the word similar would be better rather than identical.
Of course, ma'am. That's not. I'm not wanting to retread ground that was trodden yesterday. I do have specific domain information relevant to Mr. Early's knowledge that I would like to pursue.
All right, but bear in mind I don't want to hear the same evidence that we've already had before.
Of course, I understand. Thank you. My point is the third block, which you have no knowledge of, that's identical, similar. I'd contend it's similar. This says it's identical. That's not the point I'm making. You have no knowledge of it, no previous knowledge of it, you say?
Sorry, are you talking about Dryborough or?
Yes, ma'am, I am.
Yeah.
You just, in answer to my question, you stated that apart from the 2 blocks, blocks 1 and 2 that are under discussion now, you're not aware of any similar building in the area. And I've pointed out that the feasibility study references a third identical, which is actually similar building. Yeah. So may I ask what you actually know of that third block?
I've no experience of the block on Dryborough Road. I haven't been in the building.
And indeed, you weren't aware of its presence?
I was aware of its presence.
You weren't aware of its similarity to the 2 in question?
Yes.
So when I asked you the question, are you aware of any similar blocks apart from block 1 and 2 in the area, and the answer was no, why was the answer no?
Again, as far as I can see.
Well, my question is, Mr. Early, do you have any knowledge of any refurbishment works that have been carried out at this third block, which you claim not to have any knowledge of? Are you aware of any refurbishment works?
I'm aware that it has been re-roofed. That's all.
And my interest in your appreciation of the work at that block is driven by the feasibility study. Did you consider at any point the works that have been done at the Dryborough block when formulating a feasibility study for this project?
We did not.
Cost engineering techniques, are you familiar with bases of estimate?
No.
Do you have experience of cost engineering?
No.
Okay. Sorry, I assumed that you would. Would you be surprised to learn that one of the most appropriate bases of estimates, if it is available for any costing of any project, is to take actual costs from a similar project and apply cost escalation in line with indexes that have been published?
Yes.
So, knowing that some refurbishment work had been performed on a identical or very similar building in recent years, did you make any investigations to what those actual costs expended were?
No.
So the costs that you've gained for the feasibility study, I think the study states that they are based on estimates received by the council. Is that correct?
Just the roof.
And do you know what the nature of those estimates were, how they were received? Were they as a result of a competitive tender process?
I'm not aware of that information.
Is it possible that the estimates that have been received could be improved upon? That it's possible that the estimates received weren't the very best negotiated prices that might be available?
I couldn't possibly comment on what happened in 2008 with a project I wasn't involved in, so I couldn't respond.
But would you agree it's possible?
I can't respond.
The works at Dryborough to install a pitched roof had actual costs of £122,000 sometime after 2005-2006. Yes, ma'am, it's, I'll find the reference.
I've just forgotten. It seems familiar, but could you give me the reference right enough?
I don't have it to hand. I believe it was in the same letter which contained the questions recently that caused all the activity.
Driver refurbishment costs. Samson, do you know whether we've got the driver refurbishment costs before us in any of your documents?
I think it may be referred to in the EIR response. I'm just checking the document number.
So that would be a December document then.
If it helps, ma'am, that appears to be document 132. Is that the response?
EDC 132?
Yeah, is that the response to the Freedom of Information request?
I think it's also referred to within the precognition of Colin Miller.
Yeah. I'm having trouble finding it, I must see, but... Yeah. EDC 132, Mr. Farrell, is a letter, an email, I think, but it was a letter to Mr. Ferguson from the council in relation to Mr. Ferguson's request for documents. Are we in the right area?
Ma'am, I have it here. It's in the letter that we were referencing earlier, which is from FMC Solicitors, 9th of September 2019, and the title is Mrs. Julie Ferguson, 44 Nithsdale Crescent, Bearsden.
Oh, I see. The response to objection letter. Is that where the figure is?
I think it appears in several places, but it's certainly in there. It's a bullet point 1 on the last page.
So it's the letter. It's the ADC 005 is a letter to Mrs. Ferguson. And sorry, bullet point in the last page of the letter or the annex.
Of the letter, it talks. The authority believes that the nearby block referred to by the objectors is the block of flats comprising 19 to 39 Dryborough Road. The authority acknowledges that the following works were carried out to that block. There are then 3 bullet points: a new pointy roof, new windows, paint the close. And it's the top bullet point: installation of a new roof in 2005/6 at a cost of £122,260.
I mean, that's not in the letter. That's in the. There we go. I found it. Right. It's actually, I think, on the annex, Mr. Farrell. Right. Good. So the source of the information is not known to us, but it's been passed on to the Scottish Government by the Council at that level. Installation of a new roof at £1,022 in 2005-2006. Have you got that, Mr. Earley? Yeah. Could you have another go at your question, just so we remember what it is?
Thank you. So given that the cost of the pitched roof at Dryborough is known to be £122,000 in 2005-2006, and that the cost now from a quote obtained, we don't know under what circumstances, is £653,000, that's a 535% increase. If we apply the prevalent RPI increase for that same period, we would come to a figure of 295.4. My assertion is that the best basis of estimate for a pitch roof on Block 2 would be reference to actual costs plus escalation, which would resolve the figure £295,000 rather than £653,000. My question is, I think this is symptomatic of a general feeling of perhaps bloat in the figures found for the refurbishment. I think in response to Mr. Ferguson's questions about maybe close lighting or smoke alarms earlier, you suggested that, well, and understandably, we don't know what we're going to have to do until we start doing it, so we've made some allowances, maybe some contingency in there. So given that a roof was installed on an identical or near identical building in 2005-2006 at a cost of £122,000, would you agree that the new estimate based on an estimate to the council from an unknown, under unknown circumstances of £653,000 may be excessive?
The cost estimate for the new roof is £150,000, not 653,000.
That's very encouraging to hear. I'd be very glad if I made that mistake. I'd like to see where I've got the 653k figure from.
The 653 includes, for the external wall insulation, asbestos removal and the common improvements that Mr Ferguson was quizzing me about earlier.
So in fact, the estimate for the roof has reduced from the actual value in 2005-2006?
In this document, 131, EDC 131, it explains the roof cost and how it was derived. It refers to a quote from 2008, which was $232,000 for 2 roofs. Presumably, that's been halved to $116,000 for 1 roof, and then reassessing under TPI from 2008 to 2018, an increase of 24.29%, comes to a projected cost of 144,178.14, which they've rounded up to 150,000.
Thank you very much for clarifying that. I'm very grateful to receive that news. Thank you. In very top-level terms, I hope you can explain some confusion I have with some of the big numbers. The financial costings for options 1 versus options 4 are in EDC 56 in appendix no, not an appendix. So in 8.1, pardon me, 8.2 for option 1, and I think 8.4 for option 4. Just intuitively, option 1 is to retain buildings. There's no demolishing, no taking stuff away. There's no rework to sewers. There's none of all of that extensive work required. And we're putting on a pitch roof, some insulation, which is, I think you say, £635,000 per block. Is that correct?
That's correct.
Thank you. But for option 1, we work up to a total cost of $3,048,000 plus some change. Let me see where we're at. Okay, for my own notes, I have a value for option 4 of $3,525,000. Sorry. No, referring to 8.4, it's 3.348 million. Is that right? Are those the right numbers that I'm looking at for the costs of developing option 4 versus option 1?
Correct.
So it's about 10% more expensive to demolish both of the blocks, design, develop, and install a new scheme of 26 homes, taking care of all of these infrastructure requirements made. And I'm sure that that's what the detailed bottom-up costings support. But just, could you help me understand why it's only 10% more? What's going on?
I think the cost per unit is more relevant than the actual works cost. And refurbishment from the ground up, not including foundations and roads and the like, is generally more costly than new build nowadays.
But just in very, very big handfuls, it costs only 10% more to demolish 2 large blocks of flats, trail all the garbage off, redo all of the infrastructure, design on a CAD system, the new development, the new scheme of 26 buildings, procure the materials, get them on site, construct that
Mr.
new...
Farrell, hang on a minute. I want to be a little bit clearer about the basis for your challenge to the costs. And you did say right at the outset, I think you used the word intuitively or something. You're saying you can't, I think what you're saying is that you don't believe that that option 4 is only 10% more expensive.
It seems incredible that it could be only 10% more.
Hang on. Are you coming at this from the basis of any expertise in costs for building?
Yes, ma'am. I have many decades' experience in cost engineering as a project manager, project planner, project control analyst.
In what field, Mr. Farrell?
Not in civils and not in the public sector, but in engineering defence fields.
I see.
It's a different domain. It's very similar skills.
But I assume that, so in your normal day-to-day work, if I can put it, you don't need to take me into any areas that we shouldn't go, but in your day-to-day work, you're accustomed with the evaluation of bids for works, is that right?
Indeed. I've worked as bid manager, and as bid manager, one of my responsibilities is to push back on absurd estimates and to validate them.
And that would be, you said yourself, I think, that would tend to be engineering projects.
Exclusively engineering. One civils project, which was the primary and secondary radar installations at Sandwick and London Stansted. You
don't need to tell me the details of it, but one civil project. But do I correctly identify that you haven't had to do with domestic building, domestic construction?
That's correct. I have no domain experience whatsoever, but I have a lot of the cost engineering experience.
Okay. Right. It's helpful to me to know the basis in which the question, the expertise coming from the basis in which the question is framed. So let's see how we go with your questions.
Well, if I was presented with this feasibility study in some professional capacity before it was published, that's exactly the question I would ask. And my question doesn't presuppose that it's wrong, but I really would like to understand how it can be only 10% more to do all of that work versus the refurbishment of some pre-existent blocks of flats to normal construction standards.
The only way I can respond is to respond with the actual figures, which are detailed at the back of EDC 131, which list all the costs which bring the table in EDC 56 to its final conclusion.
Thank you. And some of those line items, the detail of them have been drilled into by Mr. Ferguson's questions, and I think the answers typically were of the nature, well, we don't know exactly what it's going to be until we get started. We've included some contingency. Yes, it says we're going to redesign a chute. What we actually mean is we're going to do this other thing. So a follow-on question would be, what was the brief? The refurbishment has been costed at this very high figure. What was the brief that said these are the things we need you to do? And probably more succinctly, we've got a block which suffers from water ingress at a flat roof which has exceeded its life expectancy and is known to have failed. We've got an outer skin or a double-skinned wall of conventional London bricks with a cement-based render and nothing else. We need to put a pointy roof on it. We need to insulate the sides of the thing. And I think that was costed at £635,000 or thereabouts. What's the rest of it? What else are you proposing to do, and why?
The costs are based on completely stripping out the internal partitions and stair of each masonette and reconstructing so that the space complies with the current guidance for space standards, which is housing for varying needs, and also to upgrade the internal partitions to meet, and the internal floors between, not the concrete floors, the timber floors, to meet current sound insulation requirements. Which is obviously something an owner may not choose to do, but it's what the council would do with their flats.
Anecdotally, and with great experience, I can assure you that there is no sound propagation from one flat to another, or from one room in a flat to another. I've been in newer buildings which probably conform to the building standards that you're alluding to, and they do propagate noise. So you refer to internal partitions. The property's got a double skin external brick wall and internal single brick walls. There's a partition which is a plasterboard clad timber structure in the kitchen. Which other ones are you referring to? Because there are none.
Partitions enclosing the stair and bedroom on the top floor. And to my understanding, partitions between two of the bedrooms upstairs.
There are no non-brick partitions between the bedrooms. There's a cupboard that's been fashioned out of presumably plasterboard. May I ask what the issue with that cupboard is, why you would need to do anything with the plasterboard partition that defines that cupboard?
The partition between the stair and the bedroom at the top of the stair is also plasterboard.
I'm not sure which one.
In the flat surveyed.
Can you direct me to the evidence of that in the pack, please, because I don't believe that's true.
I'd have to refer back to our survey notes in the office. I don't have it here.
So nothing's been published to that effect?
Could you repeat that, please?
Nothing's been published to that effect?
Nothing's been published in these documents to that effect.
Yes, my assertion is that all of the internal walls are of single skin London brick rendered with a Portland cement based wet plaster.
Mr. Early, is that not your understanding? Can I be clear about that?
My understanding is there are both existing within the properties.
They're both types of partition?
Yeah.
And the source of your information is the flats that you did examine?
Correct.
And that was in Block 2?
That was in Block 1.
So that was in Block 1, not Block 2?
No, I didn't do a detailed survey in Block 2.
You didn't do any intrusive survey in Block
No.
2? So you're finding that some partitions are plasterboard comes from intrusive in surveys in Block 1?
Correct.
Okay. Thank you.
Thank you. So the work that you did in determining what the scope of work is for the refurbishment of option 1, what was the brief that you had from the council in that regard, and how much of it was your best practice and your own design experience?
Mr. Farrell, that's just too big a question. The brief from the council's been referred to. Mr. Early's told us which sections of the document that's before us came from the client. So we need to drill down and be more specific about the question that you want to ask.
Of course, and what I'm trying to establish, there's this massive gap between the cost to install the new roof and put on the cavity wall insulation to the 3 million odd result for option 1. And what I'm trying to do is to determine how much of that cost was mandated in the design brief from the council. And I can't think of an easy way to get to that without just asking that question.
Okay, let me see how I do then. Mr. Early, when you were given your client brief, were you given any direction from your client as to costs?
No.
None at all?
When you say direction regarding costs, were we given cost limits to work to?
Yes.
No.
No. Can you take me through the stages of the process? You looked at the buildings and the land, and then you identified your 4 options. Did you identify the 4 options, or did the council identify your 4 options?
They were identified under discussion at meetings with various other options, and these 4 seem to be getting to the crux of what the most likely outcomes might be.
So it was an iterative process with the client, is that fair to say?
Yes.
Right. Did that involve any cost discussions at that point, that stage?
Not at that stage.
At what point was it you that sent the costs out to Langmuir and Hay? Was it your...
No.
You didn't send them out to Langmuir and Hay?
No, we produced proposals in sketch form with outline plans and the like, and they started creating costs from that.
Right, but that was the material that Langmuir and Hay were given to work with, was your designs, is that correct?
Between myself and the structural engineer.
Sorry, say it again.
Between myself and the structural engineer, we provided the information that allowed Langmuir and Hay to create their costs.
Did the council give you any direction about cost limits for any of that process?
No.
Right, okay. How was that, Mr. Farrell? Did that get to the point that you wanted to?
I think it did, ma'am. Thank you very much. So, may I ask? I'm not sure if I can do this. Can I make a proposition and ask for an opinion on my proposition?
Well, if you mean, can I pose a question that involves putting a proposition to Mr. Early for his comment, the answer to that question is probably yes. So let's see how we go. But don't make it too long and get to the point as quickly as you can.
The detailed costs that were looked at yesterday and today didn't seem to stand up to great scrutiny. The gross figure for option 1 versus option 4 at a top level just seems completely insane. Is it possible that in preparing the feasibility study you were given some leeway to maybe not be as tight with the costings of option 1 because in fact option 4 was a preferred outcome by the council?
I would say that's not correct at all, no.
Thank you. based on your intimate knowledge of option 1, do you think there are potentially significant cost savings? Do you think perhaps there is work in there that you wouldn't need to undertake to meet those standards? Is there any possibility that, in fact, there is more of a cost saving than 10% in refurbishing some existing buildings?
There are an almost limitless level of degrees of improvement you could do between the quote of 650,000 up to the 3 million. So yes.
I took a look at the Dryborough block just yesterday, and one of the things that received some discussion, some fairly extensive discussion, was the refuse chute and the bin area. What they've done at Dryborough is they have installed clasps over the chutes so you can't open them. They've locked the bin doors, and they've put a couple of like Grundon skips, you know, the big things you find in the back of pubs for the beer bottles. They've got 2 of those outside the bin area. This seems to be a perfectly suitable solution to the problem of the chutes becoming jammed. The problem with the chutes, as I see it, is that they're quite small. They were probably designed for what would have at the time been appropriate, the small bags, the small waste paper bags that we had. We now have the big black bin liner bags, which is almost exclusively the content of the bin areas now. You can't get those down the chute, so welding them shut, closing the access to the bin area, giving a couple of large Grundon waste receptacles, it's working for that block, and it's been working for that block presumably since 2006. Do you see any inherent issue with pursuing that sort of a solution in an option 1, in an option 1 light?
In a absolutely minimum work required option, then yes, you could consider something like that. It still wouldn't help the fire risk situation, smoke risk situation, unless you welded up the entries into the chute at each level. But yes, it could be done.
And I'm familiar with having welding work done on my old dilapidated cars, and it's not the cheapest thing in the world, but we're talking about tens of pounds for something of that sort of size, and there's one on several floors. So it's...
Mr. Farrell, this is quite an interesting line of questioning, but what Mr. Early said, I think, may be sufficient for my purposes. He said there's a limitless level of improvements that you could do or not do. And while it is always interesting to consider arrangements for refuse disposal, I do wonder whether or not that's really going to be particularly helpful to me otherwise. Mr. Early has assisted you in saying that there's lots of things, there's a wide range of things you could do to a building to improve it. He's also said, and I think quite fairly, that although you could weld the refuse chutes shut, there would be the potential for fire and smoke issues. I wonder if it would be possible to leave it there?
Of course, ma'am, but I think what he actually said was you would need to weld them shut to overcome those issues. Just closing them with a clasp wasn't sufficient, but welding them shut would be.
Yeah, I do wonder whether we need... Sorry, Mr. Early, hang on a second. I do wonder whether we need to pursue our investigation into the bins any further.
Of course. In which case, I think I just have one final question, if I may. When you presented the feasibility study to the council, were there any raised eyebrows at the cost of option 1 as a very, very, very high value compared with option 4 being just a 10% saving? How was that information received? Was there any surprise? Were you asked to go and reconsider?
I honestly don't remember any discussion like that taking place.
Thank you very much. That's all I have.
Is that you finished, Mr. Farrell?
Thank you. Yes, ma'am.
Yeah. I don't think I've actually got very much for Mr. Early. We've questioned, we've raised a lot of issues, and I think most of mine have been answered. Bear with me a moment. Yeah, there was something you said right at the end of your recognition I wanted to clarify. Yeah, it's 4.2. Mr. Ferguson asked you about that. The inherent issues of security, ownership and management, which are generally associated with point blocks sitting in communal open space, are usually considered too difficult to resolve. Now, I'm assuming when you say point blocks sitting in communal open space, you're talking about an arrangement very popular in the 60s and 70s where you put blocks in a kind of wide expanse of green space. And are you saying that, you know, I'm just assuming this, so you've got to clarify it if I've got the wrong end of the stick. I think what you're saying is that history has shown architects and perhaps urban designers that that's not a successful arrangement of space. Is that what you're really saying? And is that derived from any particular, is that throughout the UK, or is it in the Glasgow area, or is it in Scotland? Where would you say that's, is it right out of favour, would you say?
I would say it's particularly relevant to areas where there's potential for difficulty in managing security.
Mm-hmm. There are some, history has also, I think, taken us to the point where in some situations, in some places, the residents of blocks have taken ownership of the surrounding space, and you can get activities like allotment areas or gardening, and that's something I'm thinking of, in fact, of things I've seen in and around London. Is that something you've seen in Scotland at all?
I haven't seen that, no.
No. Is that a possibility for the open space around here? Could that be handed over to the residents or a residents' association, would you say?
I think if you had a residents' association managing and encouraging something like that, it could possibly work, yes.
It might work. Would you say, I want to sort of see where you are on flat roofs. Are flat roofs completely discredited nowadays in architectural circles? Are people still trying to put them on buildings?
They're not completely discredited, but they're not flat anymore. They're at a slight angle.
They're raked.
Made to look flat.
So if they're there for a design reason, and they are tilted in some way. They're detailed differently. Is that fair to say?
Yes.
Would it be possible to put a raked roof on this rather than a pitched roof on block 2?
It would be possible, yes.
It would be possible. Would that be a markedly different cost?
Imagine it would be a similar cost.
It would actually be similar, would it, to putting a pitched roof on it?
Yeah.
Have you any basis for that observation? Is that from experience, or just thinking about it from a detailed point of view?
From experience of recent slightly pitched roofs as opposed to pitched roofs. The detailing is more complicated around the periphery, so it sort of balances out material cost.
Can I be clear? I mean, I don't mean this may not be something you're in a position to answer, but did you make a recommendation? I can't remember. Did you make a recommendation between the 4 options yourself?
No.
And is option 4, would option 4 be your preferred solution?
I think it would be the best long-term solution.
Right.
For the area.
Is it very much better than option 2 or option 3? I'm not discounting option 1 because one of the blocks is gone. But is option 4 very much better than option 2 or 3?
It depends on the criteria you're measuring against. So In terms of space standards, new build options much better compared to current space standards. The existing houses are much smaller than what would be normal for dwellings of the same number of people now.
So space standards, any other aspect that makes option 4 strongly preferable?
I would say energy efficiency. I can refer you to the matrix, assessment matrix in EDC 56.
That's the coloured matrix, is it not? Where you mark things. Options comparison, is that right? Was that what you were taking me? Was the options comparison? Is that what you were referring to?
Some of these are measured against actual criteria, like space standards. Some of them are subjective, like urban quality, scale, height, and form is subjective.
That's helpful to remind me of that. Let me just check. No, I think that's all the questions I had for you, Mr. Ellie. So, Ms Hamilton, re-examination.
So, Ma'am, I'm wondering if I could have 5 minutes just to review my notes, but there's been quite a lot of ground covered this morning.
Yes, it is 12:20. We could rise and resume at 1 o'clock, much earlier lunch break, perhaps a little shorter, which would help with our objective of rising earlier. Would you like to
and
go down that road?
Allow me to re-examine after the lunch break?
Yeah.
That would be very kind, thank you.
Okay, right. Well, in that case, we'll rise for lunch now at 12:20, and if we could all be back in our seats by 1 o'clock, please. And you're still in Purda, Mr. Early.
Thank you.
Right, ladies and gentlemen, we'll resume, and what's going to happen now is Ms Hamilton's going to conduct her re-examination of Mr Early.
Thanks, Mr. Early. Now, we had took some time earlier on today examining various costing documents, and I'd just like to be clear what each of the documents are that we've looked at in that respect, lest there be any confusion. So, could I ask you in the first place to have in front of you document EDC 101?
Okay.
And could I ask you to explain what your understanding of the costs are that we're seeing on this document? It's referred to as a cost plan.
It's a cost plan prepared by Langer and Hay, cost consultants, based on the planning application drawings that were submitted on the instruction of East and Bartonshire Council for a proposal for 26 new build units.
So are you aware when roughly this was prepared?
Application. So in the spring this year sometime.
Spring this year?
Oh, sorry, last year.
And if I can ask you to look at the last page of that document, I think again we don't have any page numbers, but if I can ask you to identify what the total cost is that we see at the bottom of that, the large figure.
3892321.
So is that reflecting an increase then on the figure that we saw in the feasibility study for option 4?
Correct.
Sorry, Ms Hamilton, I was quietly confident I did have EDC 101, but that's not the figure I have. What was the, which page should I be looking at? This is elemental cost plan. I'm wondering if my front page is, no, it seems to be the front page.
Yes, and on the last page there are various items headed up 5A through to 5H. And then over on the right-hand side, we see a total of 3,892 odds down the right-hand column.
I don't have that page. I don't have a page with 5s on it. I've got a page with 4s on it. Oh, 5A. Wait a minute, I've got the front page. That's not the last page, it's the front page. Sorry, begins 5A carriageways, did you say?
Yes, that's correct.
Right, and so where was the figure that Mr. Early took? Where's the figure that he took there?
So looking at on the far right of the page, we see a series of figures in bold, and then the largest of all of those figures is a figure of 3 million.
Right, thank you very much. I'm tuned back in now. That's great. Thank you very much.
Thank you. And Mr. Early, could I now ask you to go to document EDC 135?
EDC
135.
135.
And so again, we see this as a costings document. It's headed up again with the Lang, Muir and Hay logo on it. And could I ask you to explain what your understanding of this document is? Perhaps I can help you there by asking you to read out the title that we see at the top of the document with the underlining.
It's for option 1 costings, but I'm not sure if it came before or after the costings in the feasibility study. If you could let me check that, please. It's the same figures as in the feasibility study, but there seems to be an error in the numbers at the bottom in terms of the number of units. So I'm not sure what this document is.
So if I can perhaps help you. So the large number we see at works cost noted on the front page, if you could read that out.
3048, 3,048,000.
Okay. And the figure in the feasibility study, ma'am, if you just indulge me here just to
it's the same
take
number.
this a bit more quickly. It's we see a figure of 3,348,000. However, in broad terms, Mr. Early, you've been referred a number of times today to document EDC 131, where we've been looking at a ballpark figure of 653,000, and I think that's been referred to as a sort of more limited refurbishment option. So what's your understanding of these costings?
The costings in EDC 135 are the costings for all flats being improved to the EDC requirement.
I'm sorry, could you...
The costing of 3,048,000 is the costing for all flats in both blocks being retained and improved to the East Dunbartonshire Council specification.
Thank you. And so when you've talked about, Mr. Early, there being a range of options that one could pursue in relation to the refurbishment option, what we're seeing in these two documents is a reflection of that range. Would that be fair?
I would say that's fair, yes.
And sticking with document EDC 135, which is the fuller refurb spec, can you explain just the approach when formulating your approach to that higher specification? And you've explained earlier on that there wasn't a sort of cost limit placed on that by the council. What were the key factors which you took into account in deciding what should be in or out of that fuller specification?
The council's desire was to improve their flats as close as possible to current standards, including those set out in Scottish Housing Quality documents, Scottish Housing Energy documents, Housing for Varying Needs, and Secure by Design.
Thank you. Okay, so I'll leave those costings documents aside for just now, Mr. Early. You were asked several questions by Mr. Ferguson regarding asbestos. Now, I'm not proposing to dive into the question of asbestos. I realise that you're not an expert in that area. However, there seemed to be a suggestion that Mr. Ferguson was disputing whether, in fact, there was asbestos present in the block. Could I ask you to go to document EDC 110?
Okay.
And could you read out to me, please, the title of the document just on the front page in bold?
Asbestos Survey Report, Refurbishment Survey, 30 in Nithsdale Crescent, Bearsden.
Okay. And could I ask you now to go to the very last page of that document?
The last page being a floor plan.
That's correct. And we see some red hatching on an area and some blue cross hatching. Could I ask you to look at the legend on that page and tell us what the red hatching indicates?
Red hatching indicates asbestos present, and the blue hatching indicates no access.
Thank you. Could I now ask you to look at document 111, please, for EDC 111?
Okay.
And could I ask you to go through the same exercise for this document, please?
It's entitled Asbestos Survey Report, Refurbishment Survey, 38 Nithsdale Crescent.
And if you could turn to the back page and tell me what you see on the plan there in relation to the red hatching.
Indicates plans of a maisonette, hatched red, and the key to red hatching says asbestos present.
Thank you. Now, Mr. Early, you were asked various questions around the similarity or otherwise of blocks 1 and 2, and you were asked some questions about Dryborough Road as well. And much as I'm hesitant to revisit this, but just to be clear, from your knowledge of blocks 1 and 2, can you express any view as to how similar or dissimilar the two blocks are? And I'm thinking here in terms of design, materials, etc.
It's difficult to see from an external visual inspection any differences between the blocks other than the fact that the floor plans are mirrored and from limited access.
Sorry, could you just repeat that last part, please? Other than?
With limited access. Visual inspection.
In terms of what you have knowledge of the materials and design of the buildings, are you aware of any material differences between them?
I'm not aware of any differences.
And Mr. Elliott, it was put to Mr. Brodie yesterday that, and I'm summarising, but I think this is a fair reflection, it was put to Mr. Brodie yesterday that it was not reasonable to take account of the condition of Block 1 when considering appropriate action to take in relation to Block 2. Do you have any views on that matter?
Sorry, could you give me the exact wording again?
So it was suggested to Mr. Brodie yesterday that it was not reasonable to take account of the condition of Block 1 when the Council was considering appropriate action to take in relation to Block 2. And I'm wondering if you have any view on that.
It's a difficult question to answer in terms of the actual condition of Block 1. It's difficult to compare the two because Block 2 is obviously in better condition, but in terms of the construction of both, I would say that the solutions for both, if they were being refurbished, would be similar.
And I think in your in the feasibility report you had identified a number of inherent defects which related to both blocks. And are those what we see in section 6.1 of your report?
Okay. Sorry, are you going to ask a specific question about that?
Well, we see a number of items here listed from A through to K, and I think Mr. Brodie drew attention to these yesterday. Are these the inherent defects which you have identified in relation to both blocks?
Not necessarily defects, but areas of risk or defects. Not having done a detailed examination of Block 2, it's some assumption in there.
Okay, thank you. You were asked some questions, Mr. Early, around the accessibility of Block 2. And I wonder how does Block 2 currently fare in relation to meeting the needs of disabled users?
From memory, at the time of inspection, there was no level access to the property. And internally, the stair doesn't comply with current standards in terms of pitch and tread sizes for accessing the common area.
Any other matters?
Well, the width of the landings, the width of the stairs, and the width of internal stairs, width of internal corridors.
Yeah. I think it's been suggested to you, Mr. Early, that in terms of tackling antisocial behaviour and security issues, that measures could perhaps be taken just concentrating on the open space itself around the blocks rather than intervening to do anything with the building and in particular demolishing Block 2. Now, I appreciate that's not something you've assessed in terms of options 1 to 4, but I wonder if you can look at your matrix for me, please, at section 9.1 of your feasibility report.
Okay.
Now, if the Council was to be considering pursuing that sort of measure as a solution to the antisocial behaviour issues which have been discussed, are you able to give any sort of indication of how it would fare against the various factors which you have identified here, the factors within your matrix?
Probably wouldn't vary. I'm
sorry, can you explain that a bit further? So I'm asking how an open space only option would fare against this matrix?
Under the section security and safety?
Well, I'm
all
asking about the
aspects?
whole. I'm asking about the whole of the matrix.
The whole of the matrix, sorry. Under Section 1, housing quality, it wouldn't vary from the matrix.
So would an open space only option, would it tackle any of the things that we're seeing listed against housing quality?
Depend on the design. Private amenity space would become semi-private amenity space. There might be a couple of points additional there.
And more broadly, would the option deliver against the wider factors relating to housing quality?
It wouldn't affect space standards, technical standards, quality of the house layout, suitability of housing mix. It may score higher on private amenity space, although it wouldn't be private, it would be semi-private, and it wouldn't improve on energy efficiency. Do you want me to run through the next section, urban quality, in the same way?
Yes, I think it's fair that you do that.
Scale, height and form, it wouldn't vary. Relationship to surroundings would probably increase slightly because you could have some defensible space for people to see as private, semi-private. Security and safety, it would increase because there would be fences around part of the building. Sense of place, I wouldn't score it any higher. Open space would probably stay the same, and parking wouldn't vary. And I don't think it would have a significant change to any of the items under financial.
Okay, thank you for that. So if I can return to the question of costings, just very briefly, Mr. Earley, you were asked various questions about the comparison between the option 2 and the option 4 costs and the difference between the two, and obviously surprise was being expressed by Mr. Frail and I think Mr. Ferguson as well as to the difference between or the limited difference between those two numbers. And I think I have you noted as saying that refurbishment projects from the ground up generally were working out to be more expensive than new build projects. What has been, you've also referred to similar projects which you have worked on in terms of feasibility studies and investigating refurb and demolition and redevelopment options. So how do the numbers on this project sort of fare against other projects that you've looked at where you've been going through the same sort of exercise?
My own personal experience, recent experience has been in tenemental refurbishment, although the company has more experience in more modern constructions. So my experience, it's a similar cost per unit for tenemental improvement, although it's not a like-for-like comparison.
So when we have this fairly limited difference between the refurb, the high-level or the detailed full-spec refurb option and the redevelopment option, is this project?
I think the contractors' tenders tend to build in a high element of risk when they're tendering for refurbishment projects, which they don't build in for new build projects. So I can imagine to the residents that the costs may seem skewed, but they're based on actual fact and actual projects. I'd just like to add that Langmuir and Hay have a lot of significant experience in recently costing refurbishment projects of post-war buildings as opposed to tenemental.
So you were asked certain questions about your experience of blocks of this type. And I think I have you noted as saying that you have experience of this construction, but not shape of block. Now, standing that, do you or did you have any concerns at the point of accepting this commission that, did you have any concerns about your ability to fulfil the brief that was being asked of you in your role?
No.
And does that remain the case today?
Yes.
Okay, I think that's all I have for Mr. Early. Thank you. Thank you.
Thanks, Ms Hamilton. Does that then conclude Mr Early's evidence? I think that's right. Okay, well, thank you very much, Mr Early, and thank you for rearranging your schedule to be able to come today. So, our next witness, Ms Hamilton.
Will be Alison Lawrence for the council.
Alison Lawrence, is that? I thought it was going to be the gentleman from... Oh, never mind. Alison Lawrence is the next person, right? Okay.
It's just because of the timings, it's been easier to organise in this way.
Right, I see. So I didn't know that. Right, okay. So, a couple of minutes for handover.
I should say, ma'am, I'm expecting that only Mr Ferguson may have questions for Ms Lawrence because she's speaking to the question of alternative sites.
Is that the position, objectors? Who wants to cross-examine Miss Alison Lawrence? Miss Lawrence is speaking about the alternative sites, and I have no notification in any of your statements of case or statements other than Mr Ferguson's that you're interested in Miss Lawrence's evidence on alternative sites. Is it just Mr Ferguson?
I certainly would like to object, ma'am, but I don't want to speak for the other objectors in that they may not have relevant concerns that stem from their statements of case that may also be applicable to what is drawn out.
Well, I mean, I know you want to cross-examine Ms Lawrence. I assume you do. But I'm really asking the other objectors, do any of you wish to question Ms Alison Lawrence?
No, thanks.
No for Mrs Ferguson? Mr Farrell? Was that a no?
That's a no. I don't have anything.
Right. So you're right. It is just Mr Ferguson.
It's Miss Lawrence, is that correct? So, with regards to your experience at the council, what exactly is it that your role is?
Thank you, yes. I'm the team leader for land planning policy at Eastern Bartonshire Council, and so I'm responsible for policy on land use planning, economic development and transport.
Okay, and approximately how long have you been in that role?
7 years.
7 years. So if we can turn your attention to document EDC 136, it's a summary analysis of alternative sites. Is it safe to assume that it was yourself that produced that, Ms Lawrence?
Is this 137?
136.
I mean, we're talking about the alternative sites constraints report anyway, I presume. Okay, sorry. Okay.
I'd like to discuss both those documents, ma'am. Yes, ma'am.
Thank you. Yes, I have seen this before. I just didn't have this with me.
Yeah, so have you got that document in front of you now?
Yes.
Yeah. So essentially, this, as far as I'm aware, was produced in response to a document that I submitted asking the council to evaluate a number of alternative sites. Are you able to tell me why there was no analysis of alternative sites done, if this was the first time that one had been produced in response to that document? I'm not sure of which document number, but we'd be able to find it in the evidence that I submitted to ask the council to consider some alternative sites. Why was there no documents considered before then?
Mr Ferguson, are you saying that you wrote to the council specifically asking them to consider alternative sites?
Ma'am, I submitted a list in response to a requirement from the DPA that there are special requirements for intimating that there may be alternative sites.
I remember all of that. I remember all of that. We gave you guidance as to how you should proceed. No, I'm asking if you have at any time written specifically to the council asking them to consider alternative sites. I mean, in those terms.
Not as far as I'm aware, ma'am, no.
Okay, so I think your question may have been slightly misleading to Ms Lawrence. It suggested that you had done such a thing. Ms Lawrence, are you aware of the list of alternative sites that Mr Ferguson produced? Is that the basis of the work that you've done on alternative sites?
Yes, yeah.
Yeah, and that was in connection with the order that I made for alternative sites, which is something that comes out of the CPO procedure. So, Mr Ferguson, you're asking why the council didn't look at alternative sites, and you're asking what Ms Lawrence's knowledge is of that?
Specifically, the CPO guidance from the Scottish ministers states that there should be a consideration of alternatives, and I believe it's reasonable to assume that one such alternative would be an alternative site for development. What I'm really asking Ms Lawrence is, why was such a document of alternatives that have been considered as part of the process not being produced before I produced the document that led to the production of EDC 136?
Ma'am, this witness has not been involved and is not involved in the CPO process. She's purely been involved in the preparation of this document in response to Mr Ferguson's request.
Yeah, I think I understood that to be the case, Ms Hamilton. Mr Ferguson, there is a problem with your question, because you're assuming that Ms Lawrence has had previous involvement in the CPO process. And I think, as we can see from her recognition, that's not in fact the case. I think that's the case, Ms Lawrence. You haven't previously been involved in the CPO process?
No.
No. I think Ms Lawrence has been mustered for the purposes of explaining the Council's reactions to your list of alternative sites. Mm-hmm. So she's commenting on the specifics of the sites that you suggested. And it may be helpful to indicate to you that the process of looking at the available sites for housing is actually quite a complicated process and extends over a number of years and may or may not involve planners. It tends, insofar as I understand the position, well, I know that it doesn't involve necessarily specific projects such as a single CPO. It's a much broader process. So because of that, it just so happens that your question doesn't really make a lot of sense for this witness. So could you restrict yourself to what this witness is here to bring us, which is observations on the list of sites that you tendered as alternative places where housing could be constructed?
Yes, ma'am.
Okay.
So, Ms Lawrence, if we could just start in this document, site number 4 in the site objective site description, which, if a gist of that was an empty field adjacent to an existing development. It says, is it council owned? No. Partners and trustees for the firm of Kessington Properties. And given that it's a field, its current use is listed as field. Now, I think what it says with this is that it's identified in the LDP as the greenbelt. Would you be able to explain to me what that specifically means, that's been identified as being in the greenbelt?
Yes. So the document 136 is an initial assessment that was done, and then document 137 provides more detail. So in document 137, there is a section, appendix 1, and that explains the Greenbelt policy for Eastern Bartonshire Council, and that explains the functions of the Greenbelt in terms of protecting and enhancing the character, landscape setting and identity of towns and villages in Eastern Bartonshire, protecting and providing access to open space within and around built-up areas, and ensuring that proposals within the existing Greenbelt development sites are compatible with established uses and respect, protect and enhance the landscape character.
Thank you for that. So just again, to clarify what I'm really asking, we'll get to document 137. In document 136, site number 1, its current use is listed as open space, known as Cochum Park. You've mentioned there that, in response to that, that the site number 4, having been identified in the LDP as being in the Greenbelt, consists of open space. So what is the difference between the open space usage in site 1 and the Greenbelt categorisation in terms of planning status that's been applied to site 4?
So open space and the Greenbelt are defined as two different things, and these definitions are set out in Scottish planning policy, which is set out by the Scottish Government. So open space, I don't have these precise definitions to hand, but open space is land that's protected for recreation, for leisure purposes, and the Greenbelt is used as a tool to direct development to appropriate locations and to ensure that the issues that I mentioned in the previous answer to do with character, landscape setting and identity of towns and villages are protected. So the Greenbelt can include open space and include access to open space, but open space can also be within the urban settlement as well.
Thank you for clarifying that. So yeah, for site number 4, the fact that it's been identified in the LDP as Greenbelt, the other comments next to that are that residential development would not be supported by LDP policy. So I'm assuming that's the local development plan. Is that correct?
Yes, the local development plan sets out a presumption against development in the green belt unless it's within accepted categories.
Okay. Thank you. So, if I may ask, if we move on to site number 7 in that document, my description of that, which came from analysis of the available imagery at the time, was that it's a quarry which has ample space for residential housing. That's corroborated in what you said is the current use for it, which is quarry extraction facility known as Douglas Muir Quarry, and it's been identified in the LDP as being in the green belt. If it's in the green belt, why is there a quarry there?
So, as I noted, there are accepted categories of development that are allowed in the green belt. So the green belt is a tool to direct development. It's not a use in its own right. It's not a thing in its own right. It's a tool. So some types of development are acceptable in the green belt, and other types are not considered to be appropriate, and the green belt's used to direct that development to more appropriate locations. So things like a quarry would be not preempting any applications, but potentially acceptable in the green belt, because it's not something you can obviously locate, in the middle of a settlement. But it also relates to where those minerals are. So quarrying has to happen where those minerals are, and production of minerals and aggregates is an essential part of provision of infrastructure, and is required as part of planning policy. So we have to make sure that there are adequate supplies of aggregates, then there's planning in process for that.
Thank you. So, on site number 8 in this document, another empty space in Kirkintilloch, which I identified, it is identified as being council-owned, and its current use is vacant land. Now, the planning status for that is that it's identified in the LDP as a site for a new community sports/planning facility. Planning permission granted for new Kirkintilloch Community Sports Complex, and there's a reference there for that. And construction is due to commence in January of this year. Has that construction started there? Can I ask?
I'm not sure if it has started. In document 137 that we produced at a later date to 136, it's noted that construction was due to commence in June 2021, so there obviously has been some slippage in the start to construction.
So again, the comment on that is that residential development would not be supported by LDP policy. Now, the LDP is a product of Eastern Bartonshire Council policy, is it not? So that's the result of their policy and their planning process. As in, the LDP is not a officially mandated legal construct which is given to them by an external organisation, i.e. they are free to, insofar as the existing policies and within the confines of the law, change that.
Mr Ferguson, you're at a slight disadvantage because the planning system is a relatively complex and layered operation, and it doesn't really lend itself to too many generalisations. And now I don't want to start this inquiry to be a debate on the status of the local development plan. Let me see if I can put the position in a way that's acceptable to you and avoid the necessity for such a debate. The local development plan is a statutory document that is created by the council in accordance with a set of regulations and which is eventually adopted by the council, and that all happens under the auspices of the Town and Country Planning Act 1997. Once the plan has been adopted, it forms a policy guidance for whether development is acceptable or not and how development should take place. The Town and Country Planning Scotland Act 1997 says that when an application for planning permission is submitted, it should be determined in accordance with the local development plan unless there are material considerations which direct otherwise. Now, that's the legal position that I understand it. Ms Lawrence will definitely understand that too, because it's part of her professional discipline. So I hope that explanation avoids the need for a debate about the standing of the LDP. Are you comfortable with that?
Yes, certainly, ma'am. It's not entirely the standing that I'm questioning. It's since I submitted a copy of the LDP as it was available to me at the time in the course of these proceedings, and it's since been changed by the council.
No, an LDP is often a document that is in a state of change, and indeed I think the council has also submitted at least sections of the LDP. Ms Lawrence is here to give you the updated position with all its complexities if need be.
Yeah. Okay. Thanks, ma'am. I'll move on. So essentially, yeah, we've gone through all this, and this was the summary response, EDC 136. If we move on to EDC 137.
So you want to look at EDC 137 now?
Yeah, if that's going to be more appropriate. Just the first thing I'd like to ask about this document. Why was it not produced before now?
Why are you asking that? Hang on, Ms Lawrence. Why are you asking that?
Ma'am, because it was submitted months after submissions were closed to objectors to be made for document submissions, and it builds on EDC 136, which is not entirely clear to the degree that EDC 137 is on the points that it tries to raise, so as to why these sites are not suitable. So it seems to me as if it's been a knee-jerk reaction in order to buy time to produce a more suitable document, which is EDC 137, which we have in front of us. And I'm just trying to understand whether or not that's the case.
From my point of view, Mr Ferguson, I'm content that what the Council has done has been quite proper. It was you that initiated the challenge that there be alternative sites, and the Council has responded to that challenge by providing you with a full explanation as to why those sites are unsuitable. If you remember my ruling on this, on alternative sites, it would have been open to me to involve the owners of all these sites, and I decided to defer my decision on whether that should happen until I'd heard evidence about them. So as far as I'm concerned, the Council has proceeded properly and has not done so in any... the timing on it doesn't seem to me to be controversial. So I'm disallowing that line of questioning.
Okay, ma'am. Thank you.
I think you were going to ask about... You're going to
yeah, I'm just trying to find the page, ma'am. Site 5, Miss Lawrence, the mains plantation Mulgai. My description of that site was that it is a covered reservoir, which appears to be disused, surrounded by a wooded area that's adjacent to an existing residential development. One of the roads in that development, Forest Drive, is visible to the bottom right of that image. The current use listed here is a disused and covered reservoir with an extent of mains plantation woodland, which is a local nature conservation site. It goes on to state that as native woodland, neutral grassland is protected from removal and damage. That's a locally important garden and designated landscape by the mains estate, and development should protect and enhance the character, important views to, from and within it, etc. And also that it's in the green belt, so there's a presumption against the development of housing in order to support regeneration, and that's included in the summary status. What I'd like to ask Ms Lawrence is, under that native woodland specification, whereby it's protected from removal and damage, can you tell me why that's different for this reservoir here? So the obvious structure, of which there's an image on the following page after Site 5, which appears there, is of the building the reservoir, which is apparently disused, which is there, and the perimeter fence around it. Why is that allowed to be built, but residential development is not suitable under the same native woodland specifically protection?
So the introduction to document 137 notes that this is a high-level assessment of all the sites. So we haven't looked into detailed site histories of any individual site. So I don't know when that reservoir dates to and its relationship with the existence of the woodland. However, as I noted in previous questions, there are types of development that is exempted within the green belt, and making an assumption that this is related to Scottish Water and therefore essential infrastructure, that's something that potentially could have been developed in the past there and been acceptable.
Thank you. I've recently had the opportunity to take a look at this site. Now, the imagery in question appears to be out of date. Would I be correct in assuming, as it says there, that this is taken from Google Maps? Yeah.
Yes, so that obviously might not be up to date. It's just to give an indication of how the site looks.
Yeah, and so this image and other images contained within EDC 137 may not provide up-to-date information as these sites currently stand in 2021. Is that correct?
No, I mean the overall site assessment for each site provides a high-level assessment of the site. If more information was required by the reporter, including a request for site visits and so on, that could be accommodated. But this is simply to give a high-level assessment of each of the sites that you submitted, so that a good explanation can be given of the site.
Thank you for that. So, yeah, just getting back to that point, outside of the gate, and I'll just draw your attention in the imagery, that satellite image taken from Google Maps. There's an access road to the south of that obvious structure, which is the reservoir. Do you see that?
Yeah.
Yes, ma'am. Yeah. So to the left of that road, in this document, on the outside of that perimeter fence, there on the left-hand side of the road, there appears to be nothing but grass or woodland there. There's no structure of any kind. Would you say that's accurate? Yes. Yeah. So my point, ma'am, is that since this photo has been taken, then there is a large generator standing there at that portion of the site. So with reference to how the disturbance caused to the native woodland by the production of this structure, which may have been a long time ago, I'm just curious as to why there's been always continued disruption then to that neutral grassland by the introduction of a generator.
Hang on, Ms Lawrence. Ms Lawrence did say this was a Scottish Water asset. When you say you've seen a generator, is that because you've seen it when you visited the site?
Yes, ma'am.
Do you have any information as to why that generator is there yourself?
I didn't think that would be relevant to proceedings, ma'am.
Well, I don't think this is a line that's worthy of inquiry time or investigation, that there be a generator on a disused infrastructure site. It could be for a lot of reasons. And as Ms Lawrence has explained, particularly when we're talking about operational matters, it's quite possible that there would be a requirement, possibly even an urgent requirement, for power to be brought to a site that might be disruptive of natural heritage interests. Mm-hmm. It's not conclusive either way. What we're focusing on, I hope, is the suitability or otherwise of these sites for housing. Mm-hmm. And going into that sort of, that really doesn't take us very far, is really what I'm saying.
No, absolutely, ma'am. Really the point I'm getting at there is it safe to assume that a lot of the imagery presented here is probably going to be unsuitable for purposeful analysis to derive useful information about the areas in order to aid decision making?
So no, Mr. Ferguson, I'm not going to accept that to be the case. This is what it is. It gives me the full standing of the site. It would be as useful to me, I think, with no imagery. It's been enhanced by the production of available imagery, but it won't be the imagery that is of assistance to me, it'll be the words.
Site 8 in document EDC 137, land west of Donaldson Street, Kirkintilloch. Its current use is listed as vacant land. Its council area is Eastern Berkshire Council, and the land is owned by Eastern Berkshire Council. Would you be able to tell me why, in the image on the left, there's a large vacant space in the centre of that image? The satellite image taken from Google Maps. Would you be able to tell me why it wouldn't be suitable to develop properties there?
The document is setting out that there is planning permission already for that location for a new sports facility. Yeah. In
Eastern Bartonshire, we already have a number of sports facilities, such as, the Allender Leisure Complex. And
Mr. Ferguson, I'm afraid I'm going to disallow this line of questioning. If planning permission has been granted on a site, any proposition that the council acquire it from the existing owner and build housing on it would entail compensation for the loss of a planning permission. It's just simply, it just doesn't fly. It wouldn't be. It almost never happens, and it would be financially very implausible. I think it's an unreasonable proposition to put to the council. If planning permission's been granted for a piece of land on your list, then the assumption is that that's what the intended use is.
Yeah, they wouldn't have to acquire it, ma'am. It states that they're the landowner.
Sorry?
It states that they're the landowner. They wouldn't have to acquire the land.
I may have used the word acquired when I should say the revoked. The council would have to revoke the existing planning permission potentially. So what I'm really saying is this is not a reasonable line of inquiry, and I'm disallowing it.
Thank you. In a lot of these site analyses, Ms. Lawrence, it seems to be the same sort of thing, that it's open space or that it's been identified in the LDP as not being suitable for housing. Are you familiar with the site at Nithsdale Crescent, specifically the site that's under CPO?
Yes, document 138 sets out the site assessment that my team did of that site as part of the Local Development Plan 2 process.
So, just in your opinion, from a purely policy perspective, as it relates to open space and the green belt, and in particular, I believe it's policy 10, but please correct me if I'm wrong. With regards to the protection of world heritage and the presence of the Antonine Wall at the site, why is the site at Nithsdale Crescent more suitable to demolish and then construct new residential property than any of these vacant sites which appear to have been designated for sports centres, which to me would seemingly be less of an important need than affordable housing and other strategic initiatives?
My precognition explains that it's not an either-or or a comparison. We're not ranking sites against each other, so just because one site's suitable for development doesn't mean that another site isn't or is. So each site is looked at on its own merits and is assessed for any proposed development. So, I mean, in the case of Nithsdale Crescent, you mentioned the Antonine Wall World Heritage Site. So that is looked at in document 138, and there's comments included from heritage Historic Environment Scotland. So that is looked at to make sure that that doesn't prevent the principle of development on the site.
Thank you for that. Just before moving on to EDC 138, if I could just ask you quickly with regards to the LDP, believe it's document EDC 102 refers to the proposed local development plan 2020. There's a number of housing sites within that, one of which is 2.H8 Nithsdale Crescent, and the indicative capacity for that site is 26. There's a number of key requirements there as well that are listed, namely that it's 100% affordable, protect the Antonine Wall World Heritage Site, an archaeological evaluation required, a number of others, but also ensure provision of direct pedestrian access to local services, including shops, primary school and bus stops on Duntoker Road. 24, Mum. Yes.
Appears it's something else.
Yeah, it appears to be an extract from the proposed LDP. It's
is this the council's? Is this the council's document?
Yeah, EDC 102.
102. That's fine. Sorry. Thanks very much. Page 24. Carry on.
Thank you, Mum. Basically, what my question is around this, Ms. Lawrence, is that given that housing of this kind would expect to be produced by the housing department from a ring-fenced fund that they would need to use to develop this social housing, is it your opinion that, as it stands, it would be 100% affordable?
These are key requirements that are set out for every housing development in the plan. There's different key requirements for different house types, and these are there to guide the planning application process and are taken into account in the planning application process in terms of determining a development against the development plan. So in terms of what might come forward, in terms of what's in the planning application, that could differ from what is in the plan, and that's not something that I have locus over. This is there to guide that process.
Thank you. And just from your own awareness and familiarity with the site, at Nithsdale Crescent, letter H there, maintain and enhance pedestrian and cycle access through the development site. There's currently pedestrian and cycle access at the Nithsdale Crescent site because you see people walking, cycling through there every day. What would the proposed development add with regards to key requirement H?
The key requirement H notes maintain and enhance, so we don't want to lose the access that you mentioned already, and it could be also enhanced. So this could potentially mean a change in terms of the location of paths and so on, but just to maintain that overall access. So the local development plan, it also has policies on design and placemaking and on transport, and they set out requirements in design terms and in access terms as to what we would require. And this is the point of this key requirement is to draw attention to that requirement on the site. And really these key requirements are there to make sure we have a high standard design on sites.
Thank you for that. Just one more question on this document before we move on to EDC 138. Key requirement D, where it states flooding and drainage policy to be met, in particular due to surface water flooding. I'll need to find it if not, but are you familiar with an internal communique which was submitted by the council as evidence from, to the best of my knowledge, Scottish Water and communication with Eastern Bartonshire Council regarding the flooding and drainage conditions at the Nithsdale Crescent site?
information to let me identify it. Are you thinking of the planning application consultation responses?
No, 125, ma'am, and it's the 23rd of March 2020, Eastern Bartonshire Council, that's just the address. So it's from, it's to Fraser McNair from Scottish Water Development Operations.
Sorry, what number is it?
124, sorry.
124, it's 124, 124, not 125.
Yeah, apologies, Caesar.
Right, so that is one of the planning application consultation responses.
Yeah.
It's not an internal communication as such, but could you hang on until I get my hands on it? Oh dear.
Just to clarify, I've not seen this document, but I don't. There's no reason that I would have seen this document.
Yeah, for a planning application consultation response, you wouldn't have seen. Yeah?
No.
So the answer to the actual question is: are you aware? Is Ms. Lawrence isn't aware?
She's not aware.
Do you want her to look at it?
Yeah, I mean, if you'd be able to speak to that, would that kind of fall within your expertise?
I wouldn't be able to speak to it because it's not my document. It's.
No.
But you may want to comment to it. Does Lawrence have it on the laptop?
Sorry, download issues.
Right, 124. Carry on, Mr. Ferguson. What was your question about this?
So, yeah, in that document, there's a heading which reads surface water, and within that, Ms. Lawrence, it says, for reasons of sustainability and to protect our customers from potential future sewer flooding, Scottish Water will not accept any surface water connections into our combined sewer system. There appears to be, in recent memory at least, extensive surface water in the event of rain at the Nithsdale Crescent site, and I believe that's been noted in other documents as well. It's been discussed as part of option 3 and option 4, which are proposed development options under consideration in the CPO. With Scottish Water saying there that they wouldn't accept any surface water connections into the combined sewer system, how, in the event of the proposed development, how would surface water be mitigated to meet key requirement D in the proposed local development plan?
The general answer that I could give you is that in a planning application, it may or may not be the case that further engineering details are required by Scottish Water to see how drainage is rectified at the area. Of itself, Mr. Ferguson, it's not controversial. It's quite a routine thing that is said. There are many areas, urban areas in and around the city and its suburbs and elsewhere in Scotland where, in current circumstances, flooding is happening more regularly than before. I think we all know why. So what I'm really saying to you is that's not a controversial issue, and it's not. I certainly wouldn't regard that of itself as being a bar to development of the site, no. Under either option, under any of the options.
Thank you, ma'am. Yeah, so just final question, sorry, on 137, before going on to document 138. It states planning permission status on the last page of that document, and that reads, a planning application for 26 housing units has been submitted and awaits determination to subject to the submission of further surveys and supporting information. And no letters of representation have been received in respect to the planning application. To the best of your knowledge, is that the current planning permission status of the proposed development?
My team's not responsible for planning applications, so I don't have any information on the status of the planning application beyond what's in that document.
Okay, thank you. So moving on to EDC 138, which is the individual site assessment, site reference S360. So there's a number of images again in this site, along with.
Whereabouts are we?
EDC 138, ma'am.
138. Sorry, wait a minute. And sorry, which page? What, is it? If it's
so I'm looking at, in terms of imagery, I'm looking at 311, 312. Just
312. Thanks. I'm with you.
Moving
I'm
through.
with you.
But sorry, my question to you, Miss Lawrence, is that one of the parts of this information provided by EDC Housing Service, was that provided by the Housing Service to yourself, or are you part of the Housing Service? I'm not clear on that.
No, I'm not part of the Housing Service. I'm part of a land planning and development service within the council. And the Housing Service provided this information that's included in there. That section where it says information provided by EDC and then Housing Service in brackets, for other sites generally it would say information provided by and then the name of the developer or landowner, so it would be different in each case in terms of who the developer or landowner was.
Yeah, just the source of that information. Thank you. So it says there, proposed development, 20 affordable flats and 7 affordable houses. So it's fair to say that's 27 dwellings or properties in total. Is that correct?
Yes.
Yes. And yet we've just seen planning permission status that states, to the best of your knowledge, that a planning application for 26 housing units, and I'm aware you don't deal with that, has been submitted. Is there any reason for the difference there that would be apparent to you?
That's quite common. In the local development plan, we actually put the capacity as being an indicative capacity. The time from when a site is first considered to it getting on the ground, it goes through the local development plan process and then the planning application process, and quite often there'll be a slight change in number of units as further work is done by the developer to ascertain what the capacity of the site is. So in this case, obviously a difference of one house, but it can be more than that depending on the size of the site and the different constraints on the site.
Thank you for that. So from all the planning we've seen, and we just had the opportunity to speak to Mr. Early, who's been involved in a lot of that. All of the plans for proposed development seem to suggest 26 dwellings, and all the evidence submitted by the council, except for reference to certain other options where it may be 24 or potentially mistakes in some documents where it's listed as 25. There seems to be no provision for a proposed development of 20 affordable flats and 7 affordable houses. I understand that that's an indicative capacity, but have you seen any other documents that would suggest that EDC intends to develop another affordable house at the site since the evidence that's been submitted?
As I said, the number of units changes, and from my point of view, in terms of policy and the principle of housing on that site, it's not hugely relevant, particularly when it's only one unit different. I mean, this was feasibility analysis that was done at the start of the local development plan process, so things do move on, as I said.
Yeah, but thank you for that. But to the best of your knowledge, there's no actual solid plans which have been produced to support the development of that indicative capacity of 27. There's nothing concrete, no?
That was the figure that was given to us at that time.
Yeah. Thank you. I'd just like to ask your thoughts on the deliverability section of that same page, which states that one of the blocks has been empty for 4 to 5 years and is due for demolition. That's obviously out-of-date information. Would you be able to tell me when this document was produced and specifically when this information was provided to you by EDC?
It was produced in 2019. We started the local development plan process in 2018, as noted in my precognition, and the sort of early engagement and evidence gathering was done between November 2018 and May 2019. So it was that kind of period where we gained information. We produced the main issues report and published that for consultation in the June of 2019, so all the information that we had was gathered before that point.
Thank you. So the kind of meat of this document, I suppose, is the assessment summary, which is two pages after that section we were just looking at, which states the site has potential for development. Would you just be able to speak a bit to why specifically that assessment's been made?
So the precognition notes that we looked at sites against criteria, and the site assessment is a sort of high-level summary of the analysis. So it's there to provide sort of high-level information on the work that the team has done that feeds into the development plan process. So you can see on page 3 the site plan or constraints map, and that notes all the designations that are on the site. So you can see in that the only designation is the Antonine Wall, otherwise it's within the urban settlement. There's no other designations affecting the site. And then in terms of the information that was provided by the key agencies, that didn't raise any significant concerns that would prevent development, and also in terms of the strategic environmental assessment as well. And the other sort of factor that we look at is around deliverability and the fact that the housing service were proactively looking at the sites. That's an indication that there is an intention to deliver. With all sites, delivery may not happen. Something might happen that prevents delivery. But that was an indication that it could happen.
Thank you very much for that. The good practice guidelines section in the proposed mitigations heading below, which is / suggested alterations, states that construction dust management, use of low noise machinery must be followed, and the erection of temporary noise screens. Would I be correct in assuming that is the same standard in terms of the policy which would have applied to the demolition of 8 to 28 Nithsdale Crescent?
I can't answer that. I mean, the point of this is because those proposed mitigation measures come from this policy assessment and the SEA, the Strategic Environmental Assessment, and one of the factors that the SEA looks at is air quality. So these bullets are just thinking around the issues that may arise. The Council has guidance in terms of construction management for planning, and typically planning applications will look at that and provide advice to the applicant, and that may extend to conditions being placed on the planning permission if that's granted. So this is just a sort of general statement in terms of the demolition of the other building. I don't have any knowledge of that. So
essentially, what I'm getting at here is, if a company or contractor the demolition of 30 to 50 Nithsdale Crescent, that task was outsourced to them, would they be subject to those policy guidelines?
That's not something I could answer at this juncture.
I think what you're asking is a slightly different sort of context, Mr. Ferguson. If I'm understanding you correctly, you're saying if someone were to be sent in to knock down block 2, would these constraints apply to them?
Yes, ma'am.
Well, I think the answer to that is going to be yes. Yeah. It's just that they won't necessarily be delivered through the process that Ms Lawrence is engaged in. There are a couple of places that those constraints would be imposed. One of them might be through a building warrant consent or road closures or other things, but they're also, construction good practice guidelines. Yeah. So I think the answer is yes, they would apply to whoever it was going in to do the work.
Yeah. Thank you, ma'am. And so what is the Council's current strategy or policy for actually enforcing that? Because I've observed contractors who were involved in the demolition of the previous building not conforming to those standards, and I'd be happy to go into detail with that if necessary. But
I think again that's out with this witness's scope of evidence.
I think that's fair. Ms Lawrence is not here to talk about the practical aspects of building or the application process, and she has made that clear. Her analysis is on the basis of the LDP.
Okay, thank you. Regarding kind of environmental protection policy, Ms Lawrence, the presence of bats in a building, if there were bats flying or roosting in a building, what effect would that have on any subsequent planning which would involve demolition of a structure?
I'm always glad to see nature coming into a public inquiry, but so far nobody has suggested to me that there's a possibility of bat roosts in and around the building in question. It's also got trees beside it. Bat roots are far from impossible, but are you saying that there are bats present in and around Block 2 and the trees?
Yes, ma'am. Myself and all of the other objectors could speak to that we have bats flying and possibly roosting in and around the property. And
possibly roosting, right. Well, if you're right about that, and that's nice to know, the position would be that any person doing any work in the vicinity of bats and bat species would be under legal constraints as to when it would take place, and it's an offence to disturb them because they're a protected species. Now, that's not useful use of my inquiry time here, because that's a legal position that affects the position no matter what occurs. It would be true of all of the options. And again, I'm sure as a planner, Ms Lawrence is aware of these constraints. It's just that she can't really bring anything to the table here that adds very much to the circumstances I'm investigating.
Yeah. Thank you for that, ma'am. So, Ms Lawrence, again, touching on that point about sewage and water systems that in the Scottish Water document we looked at earlier, EDC 124, one of the proposed mitigation measures here states that sewers and water systems in this area are currently overwhelmed, causing pluvial flooding. Would it be fair to say that from a planning perspective, it's a bad idea to build your house where it's going to flood?
I think that your question is different to your statement about the content of this, because the Scottish planning policy does require there to be no building on floodplains, which are identified by CPO, but that's different to what's included in here. And obviously, as noted in previous questioning, we've now had this letter that you've mentioned from Scottish Water, which provides more clarity on that. The work that's done to produce this document, we get input from the Council's flood officer, for example, and other specialist officers which provide information. So this is to scope out all the possible issues that there could be with the site. That provides information to the developer, but also allows us to make an assessment. And we've not had any request from Scottish Water, who are consulted on the plan, to remove the site, or CPA similarly were not concerned about the inclusion of the site in the plan.
Thank you for that. So, yeah, just to reiterate my question there, if there is existing pluvial flooding at the site, the Nithsdale Crescent site, would that be a good place to build a property, in your opinion, as a planner?
When you say fluvial flooding, are you meaning flooding from watercourses?
Yes, ma'am.
Now, is it or is it not a fact that, to your knowledge, that the site is prone to fluvial flooding?
Yes, ma'am.
You're saying it does flood from
yes.
watercourses?
Yes, it certainly does.
From watercourses?
Sorry, I thought you said water forces. No, when it rains, the area floods.
Well, the use of the word fluvial
Or pluvial.
in my understanding means that it comes from a watercourse of one form or another. That's to say, either a natural or a culverted watercourse. Now, that, as I understand it, is fluvial flooding. You get flooding from lots of other reasons, and in the urban area, it's often to do with overwhelmed sewers and other mechanisms. And that's a slightly different thing. It's not fluvial flooding, as I understand it.
Certainly, ma'am. It's not fluvial flooding. What it says here is pluvial with a P. Pluvial flooding.
So that's flooding
from rain. Is that correct? Yeah.
I haven't got that in front of me. So it's flooding. It's flooding from rain.
Yeah. Apologies. That's my pronunciation.
So now, you remember I said that I was going to that the planning application consultation response from Scottish Water. Remember I said it wasn't controversial.
Mm-hmm.
I'd have to take the same approach to this. It may well be the case that the area that you're talking to and round about the shops, it may well be prone to flooding, and that is a situation which regrettably is likely to increase because of climate change. There's going to be more rain and more heavier rain, and it's just also the case that sometimes the infrastructure needs to be attended to. That can be expected to take place. If development occurs, it can be expected to take place as part of the design process. Mm-hmm. If development doesn't take place, then it can be expected, will eventually be addressed by the Roads Authority or whoever's responsible for the drainage. My point is it's not controversial, it's fixable. It's not of itself a bar to development. Mm. So that's why I'm not really finding it particularly helpful to me.
All right, ma'am. Thank you. I think that's all my questions, Ms. Lawrence. Thank you.
Any, in fact. No, I don't think I've got any questions from Ms. Lawrence. Any re-examinations, Hamilton?
No, ma'am.
Well, that is a nice, tidy witness put through in good order. Delighted about that. Now, that takes us to 2:30. I'm remembering we're going to rise at 4:30. So I think if we take 5 minutes now while you're getting your next witness, that will take 10 minutes for getting your next witness on the stand.
And that will be, and I'm sorry again if this is not the original order, but it's Callum Scott we're expecting next. Just because of his proximity to the venue and organising the witness, that's who we're expecting.
So it's Mr. Scott from ACOM.
Mr. Scott from ACOM.
Right. Okay. So that's 14:33. We'll resume at 14:40. Yes, 14:40. So it's the reporter's clock. All other clocks are irrelevant. It's always the reporter's clock that matters. Besides, it's not far out. So 14:40. Mrs. Ferguson first, I think. Questions for Mr. Scott?
Hello, Mr. Scott. Can you hear me okay?
Yes.
Okay. I'm Julie Ferguson. I live in Block 2 of the 2 blocks that have been discussed in your appraisal. And reading through it, I see that you did the appraisal on Block 1 only, and that all the intrusive works and specialist testing all occurred in Block 1 only, and it was found that due to water ingress from the roof that most of the wood within the building had decayed to a degree. But, you know, and it wasn't viable, would you say, to fix it, to replace all the wood within the building because of having to strap the concrete and what have you?
It was the recommendation from the specialist timber damp and rot contractor that all the timbers would be, all the structural timbers anyway, as far as we are concerned, to be removed and replaced. You're referring to the means to replacing?
My understanding is that that was what was found, that the water ingress from the roof had caused the wooden structure within the building to decay to such a degree that it would all have to be replaced.
Yeah, I'm not sure exactly the source of all or some of the water ingress, but as I say, the specialist timber damps contractor identified there was water ingress, which was evident when I visited, but it was their recommendation that because of the water ingress it led to increased levels of moisture in the timber, which meant that the timbers had to be replaced if a refurbishment option was to be pursued.
Good. And that you only visited Block 2, and the only access within Block 2 was on the ground floor of the close, so in the sort of foyer area as you go upstairs into the building. That was the only place you visited within Block 2?
Correct.
And it was a wee bit unclear earlier when we were speaking to Mr Early whether any of the units within the building were entered, the apartments, either on the ground floor or above?
None of the accommodation, from my memory, was entered, certainly not by myself. I think the benefit of going into Block 2 was identified there was a discrepancy between, locally at the latest, between Block 1 and 2, and going into access in Block 2 in that regard was helpful to assist an understanding of the difference. But I think that may have been entered, I can't remember, but now between the two blocks. I think
you mean like the cellar area where there's storage?
Yeah, there was. I think that area was accessed in Block 2, whereas it wasn't in Block 1 from memory. I need to check that. No,
they're a sort of mirror image. So I think it's on the right hand as you go into the side of Block 2 and the left in Block 1. So really the only observation in Block 2 was at that level and within that storage area.
Yes, in terms of what I saw.
Okay. And later on at 3.6 in your precognition, you'd stated that there was a desk study carried out. I'm not sure what that means. Does that mean that they didn't visit the site and just use the findings of the people who did to come to a conclusion?
The desk study that I'm referring to was an initial high-level study, I understand was carried out by Scott Bennett Associates as part of the, I think this was a desk study that applied to all sites as part of the East Martinshire Council project involving these 10 plus sites for social housing.
So the people who carried out the desk study, did they rely on your findings on your visits to the site to, produce that study?
No, my involvement came after their involvement.
So do you know if they visited the site?
I don't know.
Okay, so all the sort of investigation and all the sort of structural information is only related to Block 1. All the testing and everything was done in Block 1. There was none done in Block 2. Is that correct?
That's correct.
That's all. Thank you, Mr. Scott.
Thank you, Ma'am. Good afternoon, Mr. Scott. Thanks for taking the time to speak to us today. Don't want to cover too much of the ground that's already been covered already. But just to confirm, the site visit, as it was described, that didn't involve any entry into any properties in Block 2, did it?
No, that's what the preconditioning report says.
Yep.
Not in terms of the accommodation, but just the communal area.
Thank you. So it'd be fair to say that there's been no assessment made of the interior condition to the same scale as at building 8 to 20, is that right?
There was no intrusive testing done at Block 2.
And just purely from a structural appraisal perspective, without doing such intrusive testing, would it, if you weren't to carry that out, would it be reasonable to simply assume the condition of a building extrapolated from other buildings or similar buildings or historic evidence in order to make an assessment about the current state of a building without having examined it?
Given the similarities between the two blocks and the apparent similar age, the findings from Block 1 in terms of the structural aspects is reasonable to assume that you could be relying on them in terms of things such as the precast masonry to a degree, but obviously there were implications due to the water ingress at Block 1 which had an impact on some of these elements, particularly the timber, so it would be unclear as to how that would relate to Block 2 unless intrusive surveying work was done on Block 2.
Yeah, so, sorry, just to clarify then, it wouldn't really be possible to extrapolate that to any kind of the same level of detail without performing an intrusive inspection?
To ensure that an intrusive survey of Block 2 would have given information in relation, especially in relation to Block 2, obviously. However, the similarity between the two suggested, in terms of the form of construction, what we observed externally from access into the building, yep, suggested that the form of construction was similar, so that the findings from Block 1 would, with exception to potentially the water ingress, yep, was reflective of the materials used and the strength of the materials and the properties of the materials that were used in Block 1.
Certainly. I definitely concur with what's presented as the evidence for Block 1 and the findings of EDC 6.2, and that the interior of the property, particularly the top floor. So as you go up to the very top floor of the block and on the left, so if you turn directly left in the door, which is right in front of you, not precisely sure on which number that be, but I'm sure we could find it in the relevant evidence if necessary.
This is in Block 1, Mr.
This is in Block 1, ma'am, yes. That particular property, it had a blue mould all up the inside of one of the walls on the top floor, didn't it?
I can't recall. No.
Is there any interior photography that was done in the building prior to its demolition?
That kind of aspect is out with the structural requirements that I was asked to undertake. No problem, thank you.
Obviously, building 1 was unoccupied at the time that you performed your appraisal. Given that there's no people living in it, and it effectively fell into a state of disrepair, is it safe to assume that had there been people living in it, that the conditions might have been different, that they might have, cleaned mould if it appeared, or made changes to the interior of the property which could have affected the conditions of the materials in the building at the time that you examined them?
I think that's quite speculative.
I don't think it's unreasonably speculative, actually. I think I'll allow the question.
I was aware that the property had been empty and was empty, obviously, when we entered it in various occasions. I can only surmise that a property that's empty may or may not be heated over that time, and also with the lack of occupation, any defects such as water ingress would go unnoticed for a longer period compared to an inhabited property. But that's all I can say, and I think that's what anyone would be able to say.
Thank you for that. Yeah, paragraph 3.4 of your precognition, the conclusions of the structural appraisal, it references the stage 2 of the Nithsdale Crescent options appraisal, option A, modernisation. So, and that says, on the basis that the floor joists need to be replaced in full, as advised by the specialist timber damp rot specialist. Just with regards to that, did the, as far as you're aware, the specialist damp rot specialists perform an examination of the floor joists in building or block 2, which is 30 to 50 in Nithsdale Crescent, or any of the properties in that building?
As I said earlier, only intrusive works were done in block 1.
Yeah. Thank you. Just at the end of your precognition, it states that paragraph 4.2, general observations from access to communal area in Block 2, in addition to the external appearance of Block 2, suggest that Block 1 and 2 are of a similar form of construction. Would you be able to just elaborate from a structural point of view how that assessment was derived?
The external geometry of the building, of the two buildings, were similar. When I gained access to the common area in Block 2, it was very similar to that in Block 1. Looking at old maps to determine when the buildings first appeared on maps, they both appeared at the same time. They're in close proximity to each other. It's possible they were part of a similar development, similar contractor, but that's me guessing on that latter part. But the first parts, I think, it's not unusual to assume that they are of the same nature of construction.
Yeah, thank you for that. And yeah, that is corroborated just by what comes after in your own precognition, that a review of the historic maps dating from 1985 supports that. Was there any information given to you by Eastern Bartonshire Council on why there weren't any maps from earlier than that in order to perform the appraisal of the building, or to evaluate when or where it was exactly constructed?
I can't recall.
No. Just looking at the appendices in document EDC 6.2, the desk study, the existing desk study, I know states, it talks about flood risk. So we're fortunate enough to hear from Ms. Alison Lawrence, who clarified what's iterated in Annex F, which says that the SEPA flood map indicates that no risk associated with river, tidal or surface water flooding is considered to exist at the site. I'm familiar with Floodline and the SEPA flood map as a digital product that's produced by the agency. Is it safe to say that it's EDC 6.2 Appendix F?
Carry on, Mr. Ferguson.
Thank you, Ma'am. So, it's basically, my point is, are you aware that that particular product, the CPO map, changes regularly?
I'm afraid I only deal with structural matters, so it's out with my experience and knowledge.
No problem. Thank you. That's all the questions I have, Mr. Scott. Thank you.
I don't. Okay, thanks.
Thank you. I just have a couple of questions to try and establish an understanding for the construction of Block 2 by extrapolation from Block 1 based on a perceived similarity, if that's okay. So, as I understand it, you surveyed Block 1 intrusively, as you just stated. Block 2 wasn't available to be inspected, and there's a comment in a document which is the feasibility study, EDC 56. Are you familiar with that document?
Is this the call to early feasibility?
Okay, so it's just I'd like to just see if your thinking is in alignment with the author, and that's in paragraph 2 background, and it states that the buildings, those buildings being Block 1, which has been demolished, and Block 2, which is subject of this CPO, the buildings have a flat roof which has caused major issues with water penetration, particularly to the right-hand side of the buildings at numbers 8 to 28. Would you agree that the water ingress is evident, particularly in that location?
From my memory, yes, that was my recollection.
So just in general terms, the block that's now been demolished was in a worse condition than the one that's still up. Is
well,
that a fair assessment?
It was my recollection that there was water ingress in the part of the building that you referred to in Block 1.
But particularly in Block 1?
Well, I can't talk for Block 2 because I never entered any of the accommodation in Block 2.
Right, thank you. So the water ingress, where do you think that's got into the building?
I couldn't comment. That's not something that I can comment on as a structural engineer.
Right, okay. So if we talk to the construction of the building, I think from the appraisal report that I read, is there any element of non-standard construction in the building?
No, I think low-bearing masonry walls, solid cavity, timber floors, precast concrete floors, concrete stairs, all fairly standard forms of construction.
Thank you. So the external walls, it's a double skin, traditional brick walls with some sort of cement-based render applied on the outside. Is that correct?
Yes. There's a cavity masonry wall with render. I think there was subsequent render and insulation applied at a subsequent date to construction.
Thank you. Internal load-bearing walls, they're all single-skinned brick walls?
Brick thick. From memory, brick thick. We need to double check, but from memory it was brick thick. There was an internal wall immediately to the rear of the stair, which I think was also a cavity construction.
Thank you. The floor plates between individual dwellings, I understand they're constructed from concrete rather than timber. Is that correct?
There was a combination. I think the floors 2 and 4, which were the sort of middle floors of the two maisonettes, they're of timber joist and timber floorboard construction, with all other floors and the roof being of a precast concrete units. There was the stairs were I think they're solid concrete.
Yeah. So I think we're on the same page. I just want to be explicit. The floors between individual dwellings, I believe, are of concrete, and the maisonettes, the floors between the upper and the lower floor of the maisonette is timber. Is that correct?
That's correct, yes.
Thank you. Internal walls are single skin brick.
Brick thick, so around 215 thick.
And is there anything novel about that type of construction? Is there anything inherently weird about the construction, or would you have any concerns about a building of that construction being built now?
No, many forms of domestic dwellings are constructed with timber floors and concrete precast concrete floors and load beam masonry walls.
Thank you. When we were talking to Mr. Early, we had a reference to a document. I don't now recall which the document was, and I'm hoping we don't have to go and find it, which suggested that a building of this type had a design life expectancy of maybe 30 years. Given the type of construction you've just discussed, would you agree that that building had a life expectancy of about 30 years?
It's difficult to really make an assessment on that.
Well, let me rephrase. Do you know of many buildings of that type of construction that have lasted for more than 30 years and perhaps a lot longer than 30 years?
Again, that's not something I've not really come across many forms of construction dating from that era, in my experience.
In your experience as a structural engineer, you haven't come across many buildings that are made out of bricks with concrete floors?
Could you ask the question again, please?
I'm just trying to establish whether there's anything inherently unique or different or not of a recommended type in the building that we're discussing. If there's anything in that would give it a design life in a small number of decades. And I'm thinking I know of a lot of brick buildings that have been up for longer than 30 years, hundreds of years. I don't think... I'm just trying to get your evaluation of whether a building of this absolutely standard type, made out of robust bricks and concrete, can reasonably be expected to have a life greater than 30 years.
I think it's reasonable to expect it would have a life greater than 30 years. Apologies if I misunderstood the question.
Thank you. The roof. What's the nature of the roof on the block that you did look at?
It was a precast slab roof.
Known colloquially to the layman like me as a flat roof?
It was a flat roof, yeah, constructed of precast concrete planks.
Flat roofs, are they known to have any problems, any inherent considerations?
Again, as a structural engineer, it's probably out with my remit to really make comment in terms of that particular issue. But in layman's terms, I think flat roofs are commonly known to potentially have issues due to ponding and if there's detailing issues. But again, that's something that maybe a building surveyor is better to comment on.
Of course, I'm very aware you don't want to go out on a limb, but the water ingress that we've seen, it's probably gone through the dodgy flat roof. I don't think there's any real doubt about that, is there?
I understand from discussions with members of the council that there were concerns about water ingress from the roof.
Thank you. I think that's what I was trying to get to. Now, this may not be within your domain, your area of expertise. I don't know. But I'd like to ask anyway, in your opinion, if Block 2 is in no worse condition than Block 1, as I think we understand it isn't, if the roof were to be replaced with a pitched roof, a traditional pitched roof, would that give the building any new lease of life? Would it still be, from the construction that you've witnessed, would it still be suitable to be a building?
I think we did a high-level assessment with the option of a pitched roof in the appraisal, and it suggested that it wouldn't impart a significant increase in load on the building.
Thank you. I don't think I have anything more. If I may just have a moment to check my notes. Maybe just a catch-all. The option to refurbish the block, there are several graduated variants of that option, from the cheapest option being to replace the roof with a pitched roof, and to clad the outside of the building with thermal insulation, right up to a complete refurb internally. And the difference in cost is in the order of 630k to 3,048,000, something like that. Looking at the simple costed option to replace the pitch roof and provide thermal cladding, is there anything else that in your capacity you would deem to be necessary to allow the ongoing use of the building in a safe and appropriate way?
I think I can only really refer to the guidance from the specialist timber damp contractor, who made comment that in Block 1 all the structural timbers to be replaced. In structural terms, I think also mentioned in the report that the property needed to be remain free of water and dampness and moisture to ensure that the continued performance of the concrete floors.
I think I don't want to recast your answer, but if I can just ask slightly differently, structural change is required to allow continued use of the building. Is there anything that you can think of that is absolutely necessary to be mandated as a refurbishment item, save for the introduction of the pitched roof to prevent water ingress?
I think I can only really refer to the conclusions that were made in my report in that regard.
Can you summarise your position based on your report?
Do you want me to read my conclusion from the report?
I really think I'd like you to answer the question.
Could you?
You're asking Mr. Scott to say what is absolutely necessary with the building, and
yeah.
Mr. Scott's been careful to ensure that he refers to the things of which he has immediate knowledge. And when your first attempt at that question, I have Mr. Scott noted as saying that he'd refer to what the specialist contractors had to say about Block 1. And I think, if I understand you correctly, that's what you're saying is that would have to be checked in Block 2. Yeah.
Thank you, ma'am. Thank you very much. And I don't think I have anything else.
Okay. No, I don't think I do. No, I have no questions for Mr. Scott. Any re-examinations, Hamilton?
Just having a brief check, ma'am. No questions for me, ma'am.
Right. Right. Well, thank you very much, Mr. Scott. Thank you. You got another witness stacked, Ms. Hamilton.
I wonder if you might allow me 5 minutes just to... I've got 2 witnesses waiting, and I think there may be an issue with one of their availability. So if I could be allowed a brief chat just to work out what the appropriate order should be.
Yes, certainly. And in fact, while you're doing it, I'll wipe the table down. I think we should share the skivvying. Just so as you know, Mr. Scott, we'll wipe the table down after every witness. It's not just you. Just in case you thought that, you know. Hamilton says we've made very good progress today, ladies and gentlemen, getting through witnesses, which has inadvertently created a bit of a problem about programming. There's two remaining witnesses, Mr. Miller and Ms. Gribben. Mr. Miller is not available tomorrow, although he would be available on Friday. Ms. Hamilton's expectation, and I think my own, would be that you'll have quite a few questions for Mr. Miller. So if we put Mr. Miller on just now, if we're going to rise in an hour's time, we probably won't finish his evidence. The feeling is there may be fewer questions for Ms. Gribben. If we defer Mr. Miller until Friday, that would mean that what we'll be using tomorrow for is your own evidence, the objector's evidence, and Mr. Miller would come round after that. That's all right as far as I'm concerned. That doesn't cause any real problems. But what's your own thoughts?
I think I'd like to hear all of the witnesses before I formulate my evidence.
Well, that might not really be possible. I mean, from my point, I need to get the inquiry concluded as best I can, as quickly as I can. I could give you the opportunity, Mr. Farrell, if there was anything arising from Mr. Miller's evidence that you wanted to add to your evidence, or I could get you to come back after Mr. Miller was finished. Always assuming we got Mr. Miller finished on Friday. Would that meet your concerns?
Yes. Would that be extended to all the objectors?
Oh, yes.
Thank you.
We could do it that way. But within sort of sensible limits, it would have to be specifically on a point that you could identify for me. You know, it's not a second chance to say something you wished you'd said on Thursday. You see what I mean?
Thank you.
Ms. Hamilton is reminding me to remind you that what you say must be within the scope of the written submissions that you've already said. You know, you can't bring new stuff before the inquiry. I have made that point, I think, on several occasions. Well, that's the approach I've taken. Now, what will we do? Will we put Ms. Gribben? We'll put Ms. Gribben on, see if we can get Ms. Gribben's evidence through today. Let you get away at 4:30 as you want to, and then tomorrow we'll have your evidence. Possibly, if we haven't finished Ms. Gribben could come back tomorrow morning, could she? Yeah. So we've not got the same pressure on to get Ms. Gribben absolutely finished today, but we could have a go at it.
I think as long as we are able to finish any points that we're not able to today with Ms. Gribben tomorrow.
Sorry.
Yeah, as long as we are able to speak to Ms. Gribben tomorrow, if there are any further points that we're not able to clear up today, just conscious of time, that's absolutely reasonable.
We put Ms. Gribben on and we commence Ms. Gribben's evidence. And we don't have any time pressure on us. If we don't get Ms. Gribben finished tonight, then Ms. Gribben would be coming back tomorrow morning.
I'm happy with that then, ma'am. Thank you.
Okay. So that's what the plan then. Mr. Miller is okay till Friday, and which means we have to come back on Friday. And we'll have Ms. Gribben, and then we'll have the objectors, and then we'll have Mr. Miller. And if there's anything arising from Mr. Miller's evidence that the objectors can identify that they would have spoken to, then I will consider allowing further evidence. Okay? I think we should get to a fair position after that. Okay.
Ma'am, can I just ask you about the evidence? I know we've already put in our statements and what have you. Are you allowed to put in things that have been highlighted within the hearing in your evidence?
Well, no, not really, Mrs. Ferguson. And what kind of things are you do you have in mind?
Quite a few things throughout, you know, the
well, for a
proceedings.
kick-off, quite a few is definitely not going to.
No, but you said to me, I would have to put that in my evidence. You know, you said to me when I was questioning people, oh, you would keep that for your evidence.
Yes, but remember, Mrs. Ferguson, you have submitted one statement, and of course we haven't mentioned, but there are other statements that you've made that will be dealt with elsewhere. So you have to stick within the statement that you've made.
Right.
That's you know what you've said, and that's just to remind myself about when you put it in. It came a wee bit out of time.
Is that my statement of case?
It was a statement of case, but as Ms Hamilton has said, we're treating it as a precognition, and I think you sent that in on the 3rd of February 2020. So that's what I'm expecting to hear from you. Well, I mean, you won't be needing to speak to it because Ms Hamilton will be asking you questions. We'll be taking that as having been read. Okay? Same as it's been for all the other witnesses. Okay? Right, Ms Gribben. So, questions for Ms Gribben. Mrs Ferguson first, I think.
Okay. Hello, Ms Gribbin. I've got your precognition here, and I've been having a wee read through it, and there's a few things which I disagree with, and also I'm using this document here, the response on behalf of Eastern Berkshire Council to confidential submissions. I'm not sure what number it is within the...
Mrs Ferguson, are you referring to the written submission that was prepared by the Council in response to the confidential documents that you lodged?
Precognition and the information that's supplied within it, and...
Yes, well, I understand about the precognition. That's absolutely fine. But are you proposing to refer to the Council's written submission that was comments on your confidential information? Well, I don't think that's appropriate, Mrs Ferguson. This is Callum. Could you turn off the recording and the webcast for a moment? Right, back on. Right. Okay. Right, Mrs Ferguson. What do you want to ask, Ms Gribbin?
It's intimated throughout the precognition, Ms Gribbin, that you have had extensive communications with myself and the other owners, and we have been made many offers, and actually the only contact that I have had with yourself, you've been at the 4 meetings that I have attended. The first one was with yourself and Miss McNamara, as stated here in Miss McMillan's house, and you discussed the meeting that was going to happen to decide what was, you know, the eventual option that was going to be chosen for Nithsdale Crescent. And here you had the feasibility study, which we've looked at. We didn't have opportunity to have that at the time, but you did discuss it with Miss McNamara and stated that here you put the 4 properties we owned would have to be purchased, and then went on to say, you know, once they decided at the meeting, we would be kept fully informed. Everything would be, you know, sort of passed by us, if you like, to keep us in the loop, so to speak. That didn't happen, and the meeting, which happened much later, when I met you for the second time with Mrs McNamara, it was to discuss the option 4, which was decided, and I was shown plans of that.
Sorry, Mrs Ferguson, Miss McNamara?
She's the other officer, housing colleague of Miss Gribbin, Gillian McNamara.
So hang on, Mrs Ferguson. Ms Gribbin, the reference is made to the development advisor. Was the development advisor... You need to put your phone... So there's 2 development advisors.
Yeah.
And on one was Miss... Sorry, Miss... What was her first name?
Gillian McNamara.
Gillian McNamara.
Who attended the first 2 meetings. And the second officer was Grant Davison.
And the second one was Grant
Davison.
Davison.
Who attended the 2 latter meetings.
Right, okay, so there was 2... I didn't know that. The fact that there was 2. So there's Mr Davidson. Now... the development advisor, if I can just understand the role of the development advisor, is the development advisor an officer of the council? Yeah. And what is the role of the development advisor during this process?
The role was to liaise with owners. Obviously, we were keen to progress with option 4. At the initial meeting, we spoke about the different options, including the option 4 as well as the refurbishment option. Following...
hang on, I'm just going to be clear about the exact role of the development advisor in the process. We'll get on to the substance of the course of events in a moment. the role of the development advisor, who's an officer of the council, is to liaise with the owners. Is that the primary purpose of the development advisor?
The main role is to increase the supply of affordable housing in Eastern Bartonshire Council. So as part of this, he was the lead officer in progressing the Nithsdale regeneration project.
Right. So what was your own role in this line of meetings?
So my role was to attend the meetings to support the officer and give housing advice where possible.
And give him advice?
Just everybody who was at the meeting. Not
Right.
so much him, more owners, if they needed any advice or assistance, and,
Right,
and different options that were available to them
Right,
with respect to housing.
So Ms McNamara or Ms Davidson as as the development advisor, that's the lead officer
Yeah.
trying to promote the council's preferred objectives.
Yes.
Is that right? Your own role is in supporting him,
Yeah.
but also to provide advice and support to
all parties,
all parties.
with respect to sort of different options that were available.
And is there a difference in your respective authorities? Is the advisor in a
Yes.
position to make offers, or are you in a position to do different things? How does it work?
He's a higher officer than myself. He's
Right. So he has greater authority
Yes,
than you
yes.
have, yeah. And is that the person who has authority to make offers to people affected by the CPO?
Well, I suppose at the end of the day, it's for council to make that decision.
Yes, I appreciate that, but in the context of the meeting, he's got a certain authority to make offers, to put the offers on the table, if I can call it that.
Yes, discuss the offers that were made.
Yeah, okay. Right, well that sheds light, because I had no idea who Ms McNamara was. So we've got Mrs Ferguson is putting a long question to you. She's saying there were 4 meetings. First one was Ms McNamara, and the second one with Ms McNamara. Are you ready to turn to the third meeting, Mrs Ferguson?
Yes. At these 2 first meetings, there was no offers as such. The shared equity scheme was discussed at the second meeting, and I was advised to take legal advice on the shared equity scheme. There was no offers made at that point. And I was advised, I was shown the plans, which I think I have, and I was advised to go and discuss the ins and outs of it with a solicitor, which I did. Meeting 3, there was a letter then sent, I think afterwards, offering a sort of 60-40 split of a shared equity with, the offer that you have, the first offer, and I was advised to respond to this offer within a short period of time, or the offer would be withdrawn. So at the third meeting, that was the meeting with Grant Davidson and Ms Gribben, and it was sort of put to me, well, you're going to, get a new house out of this. Yes, you'll only own a portion of it and what have you. But I felt the pressure was on to make a decision. I again reiterated that I didn't want to enter into this. I'd been advised not to, and I know that this is all to do with compensation and what have you, but a lot of the precognition here involves the meetings which are where these discussions took place. So then the fourth one was, here you put in your precognition that it was Malcolm Farrell's meeting and I turned up unexpectedly. That's not the case. The meeting was arranged for me and I brought Mr Farrell to be a witness to what was said, because what was said previously, I then received a mailing to say none of this would be available.
Mrs Ferguson. Right, so Mrs Ferguson is saying that you have incorrectly characterised the fourth meeting. That's, I think, at 2.7. A subsequent meeting was held at which Malcolm agreed to attend. However, Julie was present unexpectedly. Mrs Ferguson is saying that's not the position.
It was my understanding that...
Hang on a second, Mrs Ferguson. Can you comment on that?
Yes, yeah. It was my understanding that Mr Farrell had been invited and had agreed to attend, and there was no response from yourself, and Miss Grant Davis and I were quite surprised when you both arrived together.
No, I was asked to attend because we didn't know if you weren't there, were you? And then I asked you at the last minute to come.
That's right, I was
away. Malcolm was working away at the time. The meeting was for me, and I was wondering whether to bring someone else, and then I thought when you were there I asked Mr Farrell to come because I felt I needed someone to witness what was being said to me.
That's not my understanding. As I say, Grant and I were both quite surprised when we saw both of you together.
Well, there are the same old issues arise, Mrs Ferguson. You're giving an awful lot of evidence. The key thing is you're here to ask Ms Gribben questions. Could you maybe see if we can generate a question, please? And you'll get a chance to say all these things on your own behalf.
You've written here, Ms Gribben, that throughout discussions I noted that I had 2 sons to think of when considering my housing options. I've never noted that. I don't have 2 sons. I have a son and a daughter. And at that time, the development advisor and I understood the boys were younger than 16. I never intimated that either. And I don't understand why that's in there.
Yeah, hang on a second, Mrs Ferguson. So Mrs Ferguson has indicated your paragraph 2.8 is a bit wide of the mark. Mrs Ferguson has a son and a daughter, and the ages are wrong. Can you make any comment on that?
That was a misunderstanding on my part. I thought you had mentioned, I knew you had two children. I thought you had 2 boys, so that's a misunderstanding on my part. I also thought that they were younger, than they actually were. It was an assumption on our part, so I'm sorry for that.
Okay, Mrs Ferguson.
You've put here that I was offered social rented accommodation in the area, myself and Mr Farrell, and neither of us recall that. I don't know when that was offered. I don't have anything in writing offering that.
At one... Oh, sorry.
Sorry, hang on a second, Mrs Ferguson. Right, so you're saying that offers of social housing at council houses were offered to both Mr Farrell and Mrs Ferguson. Is it your position that that's true? But you haven't brought any minutes or notes of these meetings with you. Mrs Ferguson and Mr Farrell can't remember such a thing being offered to them. I would have thought they would have remembered if they'd been offered council houses. Can you shed any light?
All I can say is that you both were offered a social rented tenancy, and you both very quickly said you wanted to remain owner-occupiers, and you weren't interested in that type of tenure.
Was this at meeting 4? Because
No, it was an earlier meeting. It might have been the second meeting.
Right, the second meeting, what I have noted down is it was the shared equity option, and that you'd gone for option 4, and I had information relating to that, and I don't recall any offer of social housing being made at all, but who knows, it was a long time ago.
Yeah, it was.
Also, further down, you've intimated that we've had a number of meetings to discuss the options, and there's other literature has been put out to say that, you know, I was approached sensitively about these offers because, you know, it's a distressing thing to go through a CPO. Can you explain to me what you mean by the sensitive approach?
Well, we obviously understand that it's a distressing time for owners. We had several meetings with owners, and we tried to be sensitive throughout the process. I'm sorry if you didn't feel that was the case. It was never our intention.
I certainly didn't in the last 2 meetings feel that was the case. And also, this number of meetings, and the development advisor had several further discussions with owners, not with me, and I don't know why that's in there. Why has that been put in? We've had several discussions. After the 4th meeting, I was advised that, you know, if I didn't accept the lower offer, there would be a CPO. I would be given £60,000, which is the district valuer's value of my home, and basically put out of my home. And I left that meeting extremely distressed, and I have had no further communication from the council offering any other support, advice or offers. Sorry, I'm not sure why that's in there, saying that the development advisor had several further discussions.
Ms Ferguson, I've just asked Ms Gribbin to sort of answer that point.
Yeah, it's my understanding that Grant Davison did have discussions, not with yourself, I believe, but some of the other owners. Yeah.
When you say it's your understanding, Ms Gribbin, how do you mean your understanding?
Well, there's correspondence between one of the owners and Grant Davison in relation to the valuations.
Which other owner?
Miss McMillan.
So,
Myself, yes.
Mr Davidson did have contact with Ms McMillan.
Yes.
Did he have contact about that? So that's there's Ms McMillan and her daughter, Ms Fullerton.
Yes, who Miss McMillan was acting on behalf of her daughter, as far as I'm aware.
Right. So Mr Davidson had contact with Ms McMillan and Ms Fullerton, but Mr Farrell, but not, in fact, contact with Mr Farrell or with Mrs Ferguson. Is that your understanding?
Yes, but Miss McMillan had sent some correspondence to Mr Davidson.
See, the problem I have with it, insofar as I'm really, my interest in this is the degree of impact, but as I've already explained many times, there's limits to how much this is relevant. But I'm not clear why contact with one owner is supposed to be relevant for contact with another owner. Surely each owner should be approached individually about their situation.
It was actually Miss McMillan who approached Mr Davison, though.
Well, yes, but the point you're making to Mrs Ferguson's trying to set the record straight as she understands it to be, was that she hasn't had lots and lots of meetings and lots of contact. She's only had 4, and what you seem to be referring to is contact with the owners in the most general sense. But surely that's not really correctly the position. It should be the dialogue that you have with each individual owner in respect of their interest. Yeah. So meetings with one aren't relevant to meetings with another. Do you see what I mean?
Yeah.
Yeah. Okay. I'm just trying to narrow the difference between you in terms of understanding. Next question, Mrs. Ferguson.
3.1 of the precognitions. Given that the 2 owners of the CPO properties were owner-occupiers, the Council considered carefully the arrangements which could be made to rehouse them and family members residing with them and minimise the impact of the CPO. I've not been made aware of the considerations or arrangements for me and my family. No one has contacted me after the 4th meeting, and I don't understand why that's the case. When you put in here that there were careful considerations and, you know, the arrangements which could be made, all I've been offered is a shared equity offer.
Right. So, Ms Gribbin, maybe you can shed light on this. EDC 99 and EDC 100, is that the Council's offer to... Is that the Council's offers to Mrs Ferguson and another? So they are. So what I'm trying to find, Ms Gribbin, is I want to know what the council's current offer. I want to know where, as a matter of record, what the council's current offer is. I want to know that there is one, and I want to know what it contains. I will exercise some discretion as to what is and is not relevant in it, but what's the current offer to Mrs Ferguson? Where will I find that in the council's papers?
I'm not sure. Sorry, I'm not sure what you mean. Do you mean the financial offer?
Well, what does the council have on offer to Mrs
Oh,
Ferguson?
sorry. Well, we offered Mrs Ferguson.
I'd quite like a reference to a document, actually, Ms Griffin. Okay, I understand that there's a document in the that records the terms of the offer to Ms Ferguson. Would you, Ms Hamilton may be able to assist you. EDC 11?
Oh, sorry, yes. So you're referring
to...
to...
Farrell, let's focus on Mr... Well, I've got... Is it EDC 12 for Mrs Ferguson?
Yeah, sorry, you're referring to the offers that were made to purchase the properties. There were two separate offers made, one in November 2018 and one in March 2019.
Yeah, so what's the current... What is what's the current off? What is currently on the table for Mrs Ferguson? Is what I want to know.
£130,000.
No, where will I see the details of it? Is that ADC 12?
Yes, it's in the letter.
So that's the letter of the 18th of March?
Yes.
And is that offer still open?
Yes.
Right. That's as far as I want to take that point. Okay. Right, Mrs Ferguson, next question.
The cash offers, I've said from the very beginnings, of no use to me. I need somewhere to live with my family.
That's exactly the kind of area that is not relevant.
We're not discussing. Okay, that's fine. I have no more questions.
Right. Mr Ferguson, questions for Ms Gribbin?
Yeah, thank you, Mum. Just to clear up one point before I begin. As it directly relates to Protocol 1, Article 1 of the European Convention of Human Rights, which, as far as I'm aware, is legislation that is relevant to the process, inappropriate conduct of any kind, which would not have otherwise occurred without the CPO, that is to say, the root cause which has enabled that inappropriate conduct is the promotion of the CPO. Just to confirm, from a legal point of view, we're saying that's not relevant to the human rights considerations of the case.
Are you asking me for a question, for an answer in respect of a question of law?
Just to clarify there, what was said, as far as I'm aware, is that the Council's conduct in the manner of the promotion of the CPO is not relevant. However, what I think my mother was trying to say is that that inappropriate conduct would not otherwise have occurred were the CPO not promoted. So is that not a legally relevant point?
Well, no. What's before me is the assessment of the CPO as to whether it should be confirmed or otherwise. And the Council has to establish that it's in the public interest that it be promoted. And during that process, regard is had to the effect on the affected people. And that's where the assessment of a incursion in human rights and whether or not that is justified in the proportionality question, that's where all of those are engaged. And that's where it all gets wrapped up. I don't think the root cause point that you're making sounds like a bit of an outlier to me, but it certainly doesn't render, it doesn't undermine my point that the conduct of the Council in getting to this point is not something that can be taken into account. I mean, what it boils down to is you and your mother are saying to me, don't confirm this CPO because the Council are a bad Council. They're of a bad
That's not
character.
what I'm saying to you. That's not what I'm saying to you.
Well, I think that is what you're saying.
No, the assessment of this compulsory purchase order is, as correctly mentioned on several occasions, your prerogative. I don't mean to tell you anything with regard to that. All I'm saying, I'm just trying to clarify, and I think that does clear it up for me, that inappropriate conduct and the fact that the CPO is the root cause of it is something that will not be regarded in that decision-making process.
I mean, I think you're taking a single strand that might be relevant in a particular broad-based, human rights-based challenge, and I think you're taking it out of context. That's where I believe it to be the case. What I am absolutely clear about is that the legal position is that the conduct of the council, bad administration of the council, bad behaviour in conducting the negotiations, if any has occurred, breaches of confidentiality, failures to maintain the building, all of these things may be acts that are worthy of criticism, but this is not the forum in which to consider them.
Okay, ma'am. Thank you. That's useful for me.
Okay.
Good afternoon, Ms. Gribben. So in your recognition, it states that in paragraph 1.3.1 that your evidence will address the following matters. In paragraph 1.3.1 is engagement with the affected parties. To be perfectly honest with you, before this PLI, this public local inquiry, took place, I didn't know you existed. In the event that this CPO is promoted successfully, currently I will be made homeless. In your opinion, would that make me an affected party?
If you were to become homeless, then the council would have a duty to meet your housing need.
Yeah.
I don't think that's quite what Mr. Ferguson was
asking.
asking. He was asking you whether, as a member of a household, and somebody who's a young adult who currently lives with his mother, if the effect of this, if the CPO is to make it is to remove the home from the family, he would be affected. What he's really asking you is, shouldn't he have been one of the people who was consulted?
Yes, that was an error on the council's part.
Why was no notification given? I'm on the electoral register, both the open and closed electoral register, from which my details would have been apparent. Why did the council therefore not feel that it had to notify me of my rights?
I can't answer that, unfortunately.
And would you say then that you hadn't engaged with me at all during this process as an affected party?
No, we hadn't.
I can just say, Ms. Gribben, there's not only Mr. Ferguson, but there's his sister, Miss Ferguson. And as I understand the position, you haven't engaged with, well, I haven't heard any evidence that you have engaged with Miss Ferguson either. So is it the same case that you haven't engaged with Mr. Ferguson? You obviously are concerned that that should not have happened. Is it the case that you should have engaged with Miss Afton Ferguson as well? Yeah.
We should have engaged with all parties, and that was an error on our part.
Okay, I accept that. Thank you. Paragraph 2, engagement with affected parties, 2.1 of that section states, the Council's engagement with the affected parties between March 2018 and May 2019 is summarised in document EDC 113. I have that document in front of me. Are you able to see that document, Ms. Gribben? Yeah. Okay. So just going through it, October 2016, committee report requesting permission for a feasibility study to be undertaken. February 2018, feasibility study complete. 3rd of May 2018, committee paper presented. Discussion with owners. Now, I want to be really specific here. The wording you just used when questioned by Mrs. Ferguson was that your job was to liaise with owners, whereas in your precognition it states that your role involved engagement with the affected parties. Would you agree that there's a difference between an owner and a non-owner, in that they can both be affected parties?
My role was to support the development advisor and to give advice and assistance where I could. Sorry, can you repeat your point?
Yeah, so just the same point there, 1.3.1, in your precognition, that your evidence will address the following matters: engagement with the affected parties. So in your role, presumably that involved engagement with the affected parties. Is that safe to say?
Yes, I accompanied the development advisor to the meetings, yeah.
Yeah, and do you recognise that owners are not the only affected parties by this CPO?
You mean yourself? Yeah, I now do, yeah.
Yeah. So, where it says discussion with owners in EDC 113, it would really be more appropriate to say discussion with affected parties, wouldn't it, as part of a successful engagement strategy?
Yes.
Yeah. Would you say that your engagement with affected parties, or the council's engagement with affected parties in the promotion of this CPO, has been comprehensive?
The engagement really at the start wasn't about the CPO process. That wasn't mentioned at the start of the process. It really became the decision of council to progress the CPO, which officers had to act on. But then the initial meetings were really to engage with owners to try, and obviously we were keen to go with option 4, and we were trying to negotiate with owners about selling the property to the council.
So, yeah, on point, paragraph 2.3 of your precognition, at this meeting the development advisor discussed the outcomes of the recent feasibility study. All options were discussed, including refurbishment of the block and associated costs, as well as demolition of both blocks with new build housing provision on site. The development advisor, is that yourself, Ms. Gribben? No. Which development advisor was that? Was that Mr. Miller? Who?
Mr. Ferguson, in response to questions from me, the two development advisors, Mr. McNamara and Mr. Davidson, don't think Mr. Miller's ever been suggested was as a development advisor as such.
Okay.
At that meeting, it was Gillian McNamara.
Yeah. Okay. And yeah, it goes on to state that the development advisor indicated that if the demolition option progressed, the council would wish to purchase the 4 privately owned properties, market value as a minimum, and ask the owners to consider this option.
That's right.
In your own words, you said that the council were keen to progress with option 4.
Yes.
Where did that direction come from? Were you given that direction, or did you promulgate it yourself?
It came from the outcomes of the feasibility study. From those outcomes, the council felt that option 4 was the best option. We met with owners to discuss the feasibility study and the options appraisal. We discussed all of the options, including the demolition and new build, as well as refurbishment. We did go through those options. Yep. But we did make it clear we were keen to buy the properties. We encouraged owners to consider selling the properties to us. We also encouraged them to have valuations undertaken, and Miss McMillan agreed to have number 34 and 48, which were her property and her daughter's property, to have valuations undertaken.
Yeah. So what this says to me, Ms. Gribben, is that even though all options were discussed, including refurbishment of the block and associated costs, that was not the intent of the council. Their main effort, as it were, was to demolish both blocks by taking possession of them. Is that correct?
The feasibility study and options appraisal was discussed with was discussed at committee in May of that year, and committee decided to progress with option 4. We were then given the task to negotiate with owners about discussing potentially buying the properties from them.
And just to clarify, by committee, do you mean
Council.
the Place Neighbourhoods and Assets Committee?
I think
As an organ of the council?
Yeah, I think it was. I would need to check.
Yeah. And obviously we're unable to see those minutes, which is really the main reason that I made a motion previously, which again I was unable to get through a Freedom of Information Act request, but because the minutes of that meeting are so heavily redacted, it's impossible to see which councillors actually expressed that intent that you describe. But you've just said that you were given it. Are you able to indicate who was keen to progress with option 4?
No, I can't.
I'm going. No, sorry. Don't answer that question, Ms. Gribben. Once elected members have made a decision, it doesn't matter who voted for it or against it. And I would not be interested in which councillors had voted for or against it.
Do you accept that the demolition of the blocks, even at that time, would have necessitated a compulsory purchase order?
No, because at that time we hoped we could work with owners to purchase the properties from them. Initially, CPO wasn't on our radar. It was at a later stage that the committee took that decision to follow the CPO process.
So paragraph 2.4 of your recognition, first sentence of that, at the time the owners indicated that their preference was the block refurbishment option. From documents we've examined today, it appears that that would have been a more financially responsible option on the part of the council, and that it would have enabled them to spend funds on something else that wasn't the promotion of this CPO, had they actually done that.
Just a minute, Mr Ferguson. For clarity, Ms Gribben, this is Mr Ferguson's version of events, less than something that has actually emerged from evidence.
Yep. So it states, they were informed that this would likely result in a high cost to them due to the extensive works required. Had you seen those costings at that time in the feasibility report?
No, as I say, the development advisor led in the project, but did advise that the costs were likely to be tens of thousands of pounds. That was discussed with the owners, who did still say they were keen on the refurbishment option and wished to progress with that. That was always made clear by the owners.
Thank you. So, even though, in your own words, your job was to attend meetings and give everyone, leaning more towards the owners, advice, you were not the one who gave that advice. It was the development advisor.
That's right.
Yeah. Why, when it was your role to do so, to give advice, did you not give advice in that situation?
I gave advice on housing issues. I gave advice on the potential of owners receiving a social rented tenancy. I also gave advice on shared equity options. Those were the tenures that were available at the time.
One of the points that came up in discussion just there was the option of social rented tenancy. Just to really kind of elucidate this point, do you own a property? You don't have to answer that, Ms. Gribben. Do you own a property? No. Okay. So essentially, this is important because in the sense that you said owners are not interested in a social rented tenancy agreement, I think anyone who owns their property outrightly would not be interested in paying for social housing on a monthly basis because they've been pushed out of their home. Wouldn't you agree?
I appreciate that many owner-occupiers wouldn't then wish to become social rented tenants. Yeah, I do understand that.
So even if that was something that was offered, that would be an unfair offer, wouldn't it?
No, we were putting all options that were available to owners. We were trying to give as much choice as possible. We also offered shared equity, which is a form of home ownership.
So Grant Davidson, was that your colleague at the time? Yeah. And he discussed this option with Ms Macmillan. Is that correct? According to your
No, not
statement?
Ms Macmillan, no.
No, okay.
It was with the resident owners.
Mm-hmm. Yeah. None of whom have any recollection of that happening, or in fact there being any evidence to support that narrative?
About discussions about shared equity? It is documented.
No, about social rented tenancy.
It was discussed.
But is there any evidence of that?
I would need to look through paperwork off the cuff. I couldn't find it, but yeah, I'm sure there will be.
Yeah, because I've looked through all these documents, and as far as I am aware, there is no evidence, no concrete evidence of an offer of social rented tenancy to any of the affected parties. So why have you just stated that?
Because it happened, and the reason why it sticks in my memory is because both resident owners were really not keen on that option, because for the reason that you just stated, that they were owner-occupiers and wished to remain owner-occupiers.
And would you say that's fair for them to want to
Absolutely.
stay in control of their property?
Yeah, absolutely.
So just compensation aside, on the subject of offers, when we're speaking about offers, can you, to the best of your knowledge, define what an offer means in the context of which it's being used here by EDC?
I'm in danger of setting myself to sleep over this, but I did cut some slack from Mrs Ferguson, but I think I would expect that you would be able to understand that we can't go into the process of negotiation or compensation.
Yes, ma'am. I don't intend to. I wish to make a legal point about the nature of an offer and why one has not been made, as far as I'm aware, under Scots law.
I think I'm ruling that out of order,
okay,
Mr Ferguson.
In paragraph 2.8, you say, throughout discussions, Julie noted that she had 2 sons to think of when considering her housing options. Where did Ms Ferguson note that?
As I said earlier, I misunderstood. I knew that Mrs Ferguson had 2 children. I, for whatever reason, had wrongly assumed they were both boys, so I apologise for that.
Why would you have assumed that she'd noted that?
I don't know. It was a few years ago now. I made a wrong assumption.
So, presumably you just made that up, in effect?
No, I'm not sure we can take this point much further, and I think perhaps Mr Ferguson could just be careful with the tone of the questions that he's putting to Ms Gribben, who's here to give evidence in good faith.
Ms Hamilton does have a point. Ms Gribben has acknowledged that she made an assumption and that it was wrong, and she's even apologised for it. So, you know, I think there's no need to labour it beyond that point. I have the evidence on that point.
Okay, accept that, ma'am. Thank you. Paragraph 3 of your pre-recognition rehousing strategy. Paragraph 3.1, just below that, states that given that 2 of the owners of the CPO properties were owner-occupiers, the Council considered carefully the arrangements which could be made to rehouse them and family members residing with them and minimise the impact of the CPO. Ms Gribben, I've seen no evidence anywhere to suggest that those efforts were made. Can you tell me what that refers to?
Sorry, is this us back on the social rented housing point?
No, ma'am. This point refers to a rehousing strategy for which there appears to be no evidence.
Consider carefully the arrangements made to rehouse them. And then I think in 3.2, Ms Gribben goes on to explain what she means by that.
Yep.
And I don't think it's correct that there's no evidence I have been provided with the correspondence.
Mm-hmm. But it's safe to say, I think, that a single offer of a shared equity agreement, which is incredibly biased in favour of Eastern Berkshire Council and not in favour of the objectors, does not constitute a strategy. As far as I'm aware, a strategy would constitute a plan of action designed to achieve a long-term or overall aim, but in fact this is a short-term solution with limited objectives, that is, as has been stated multiple times today, to take control of the four properties.
You take the rehousing strategy from the heading.
Yes, ma'am.
But I think it's possibly a better use of word to say arrangements rather than a strategy. But what I'm putting to you is you're trying to suggest that there's no evidence. In fact, there is evidence. There's the correspondence, and there's some information about the meaning of shared equity. So it's incorrect to say that there's no evidence.
Yeah. What I'm really disputing here, ma'am, is that the evidence is not one of a strategy. I agree that arrangements would be more appropriate, but arrangements is not what's been submitted. It's a strategy, and a strategy suggests that there has been some long-term thought of a plan of action involving the rehousing of the affected parties, which has not happened.
Right. Well, let me see if I can take this point to the point that can reshape this to the point that's useful to me. Ms. Gribben, so far as you're aware, no individual rehousing plan specifying what social housing offer would be available to them and what the arrangements would be for, say, Mr. Ferguson and Miss Ferguson. Nothing of that nature has been provided to Mrs. Ferguson and her family. Is that correct?
Yes, that's correct. As I say, at the early meeting, when we mentioned the possibility or the option of social housing, it was declined at that point.
Mm-hmm. So you
quite categorically.
But you haven't put on record an offer to them of social housing.
No, I mean I would need to check the paperwork.
To them. We had discussed it in the meeting. The recollections clearly differ markedly, which for something so significant is regrettable. But no, that's never been confirmed.
No, I don't think it has been.
Can I also ask, if it were to be the case that any of the owner-occupiers became interested in the shared equity offer of one of the premises that would be built under option 4, presumably they'd have to be rehoused in the meantime?
Yes.
There would be a decant situation?
Yes, that's right.
Has that been discussed with them?
Yes, we did discuss if there was any decanting throughout the period that the council would cover costs.
But has where they would be decanted to been covered?
No, we'd hope it would be a local property, either owned by the council or a private rented property. But no, we didn't go into that in detail.
Right. And again, that's never something that's been specifically laid out for them?
No.
Okay. Right, thanks for that. I interrupted your questioning, Mr. Ferguson. You want to resume?
Please, thank you, ma'am. Yeah, do you feel it would be appropriate to close for today this time, ma'am?
I think certain members of your family are keen that it should stop.
As am I, ma'am.
I think we will stop there, if that's all right by everybody. Okay? So you're coming back tomorrow, Ms. Gribben, and the convention is that you shouldn't discuss your evidence with anybody at all while you're giving evidence. So you regard yourself as being in purdah, which is the phrase which is used, without regard to gender, I may say. So you shouldn't discuss your evidence with anybody. Okay then, now what we're expecting to do tomorrow is finish Ms. Gribben's evidence and then work our way through the evidence, which is really the questioning of each of the objectors. Ms. Hamilton, have you got a handle on how long you would be with each of the objectors?
I don't think I'll be terribly long.
So if we were to start at 10 o'clock, would that in any way endanger getting through all the business of the day, getting to the end of the objectives?
No, I don't think so. It would be helpful, ma'am, if we could agree an order at this point, if that's possible.
Well, the order that suggests itself to me is the order in which I've run cross-examination. Objectors, do you have any strong feelings as to who should give their evidence first?
No, not here.
So nobody volunteering? Right, well, there you are. Mrs Ferguson has volunteered. So we'll run it exactly the same way as we've done the questioning. Mrs Ferguson, then Mr Ferguson, then Ms Macmillan, then Mr Farrell.
And is this the statement of case that I've put in that will be getting questioned on?
Well, that will form the basis of what I understand your position to be and what Ms Hamilton understands your position to be. You're not going to be asked to read it out, but you're expected to keep within the four corners of what you've written down.
So I don't have to produce anything else.
Well, I wouldn't be very happy if you did, Mrs Ferguson.
Well, that's fine by me.
So what's going to happen is the same as it has been for every witness. You just take the stand, and Ms Hamilton will ask you questions. I will probably have some questions, and then after that's happened, you'll have an opportunity to say anything you want to tidy up. But just anything you want to tidy up in the questioning. Just in case anyone's confused about this, if you remember in the long letter I wrote you on the 7th of July, I explained the process. And do you remember that I made reference to closing submissions? Do you remember that? You're not nodding your heads. Might it be the case that you don't read the letters that my office sends you? I don't know why you have to read it at 2 in the morning. However, concluding submissions are important, and what that means is after all the evidence has been taken, everybody will have an opportunity to go away and think for a week about the evidence that's been run. And then you'll have an opportunity to make submissions, which should be in at the end of that week. And the submissions summarise the evidence from your point of view, and they also say what legal points you want me to consider. Now, in fact, legal points, I apply the law, but I don't make findings about the law. It's up to ministers to make findings in law. So it's very important, if you're going to make a legal point, your concluding statement should explain your point of view, because that will be transferred straight on. Ministers will see what you say in that written statement. So the function of the concluding submissions are round up of the evidence and any legal submissions you want to make. So a week to make them, and the council will have the same time, so everybody will have their first shot at the end of a week. And then I give another week for everybody to comment on the other side's concluding submissions. Okay? So nobody has to make their final statement off the cuff at the end of these proceedings. So,
Ma'am, would the council not generally have the final word?
I'm not a huge fan of final words. I like mutual exchange on the basis that it comes down to the same thing in the end. So it's mutual exchange. I think that makes absolute sure there's fairness. Anything else, somebody always thinks of something else they want to say. So there's only two shots. First, concluding submissions, and then comments on the rest, and that's the line. Just thought I'd leave. I had a feeling you hadn't picked up on that, and it's just so as you know. Right, okay, well, we'll adjourn today, and we'll see each other at 10 o'clock tomorrow morning.